Hi, this is Steve Dale. I want to thank everybody for attending today. This is going to be a very special presentation. For many of you that are professionals, you all know who Avram Sachs is. For those of you who are family members, you probably have never heard of this character. I'm here to tell you that Avram is one of the, if not the top, one of the top experts on all aspects of Social Security. Here, he's frequently on a number of listservs and that kind of thing. And I've got to tell you, when Avi, as we call him, posts something, it's something that we block and copy and save here. Let me just go through the basic biography here for Avi here, and then do a little bit of setup about what we're going to talk about today. And also for those of you that are watching for credit here, how you can make sure that you can get that credit. So Avram Sachs here is an attorney in private practice in, from what I can tell, chilly Skokie, Illinois here. It's by the way, it's 60 degrees here and we're all freezing. It's a little cooler where you're at.
A little bit.
Here. Yeah.
Oh, yeah.
So he concentrates on Social Security law and benefits. He's a former assistant general counsel for the Social Security Administration, past editor for the CCH Social Security Law Reporter, founding member of the Special Needs Alliance Advisory Council, and author of 2 books on the Social Security law. He's a member of the National Academy of Elder Law Attorneys and the National Organization of Social Security Claims Representatives, or called NOSCR, here to most of us here. He's a frequent lecturer on Social Security matters. Has an active practice successfully representing clients before the Social Security Administration, as well as in cases before the U.S. District Courts and the U.S. Circuit Courts of Appeal. He also advises clients on how to maximize their Social Security retirement benefits through optimizing optimal claiming strategies. Just a little background before we get into this. And so the title here is Maximizing Social Security Benefits for Special Needs Families. And I know one thing, not the only thing he's going to cover, but one really important thing he's going to cover is qualifying for a program called Childhood Disability Benefits. Now, this is kind of an indication how many Social Security programs roll. I do a program on public benefits, which I think we dedicate 7 slides to childhood disability benefits. Now, the slides that I cover are pretty straightforward here, but when you dig into the meat of this thing, you know, as I like to say, the simplicity and disability are 2 words that I just don't think go together. And I think we're going to get a little taste of this today. For you family members that are watching this, you know, one of the things I get as a special needs practitioner all the time here is that I want to make sure that when I pass away, my child with a developmental disability is going to be able to keep their SSI. What Avi's going to show us is in most cases, they're not going to be on SSI, especially if you put in the requisite number of quarters here for your own Social Security. And so this becomes an incredibly important program, commonly misunderstood. So anyway, with that, the other thing is this is a very ambitious presentation. I think it's breaking all records for the number of slides. So I know that there's a number of slides that Avi is going to skip through, but the entire presentation, I think, is 155 slides. That is ambitious here. And I'm sure you could add more if we had the time and ability to do that. Anyway, Avi, I am so excited about what you're going to share today. To go through just the thing about benefits, if we can go to the next slide here, is that assuming the next slide works. Okay. This program has been approved for MCLE credit by the State Bar of California here for the North Bay Housing Coalition provider for 14598 to participate and receive credit if you're either an attorney or a private fiduciary. Once again, there'll be a link, and you'll see the link as the codes come up. There's 3 codes within this program, so you'll need to write those down, and you'll need to put it on an MCLE credit form that will be provided for you. If you don't have it now, what you'll see is a link about where you can find it on the Golden State Pool Trust website here. And also to be placed on future programs, to be on our mailing list. What you should do is email Amy, AMY, at gspt.org. And at that, Avi, I'm gonna let you take off. I think that one other thing is I'm going to be monitoring questions. If you have questions, put them in the question box. I will do my best to try to get those across to Avi. I would be amazed if Avi will have time to answer all the questions, because there's a certain point where we do have to cut this off here, but we'll do our best. So anyway, if you have questions, put them in the question box. And what I'll try to do is, if I can, ask them during the presentations. And then for those that we couldn't get to, then we'll try to get as many as we can at the end. And after that, we've done the best we can. Avi, thank you for joining us today.
Thank you, Steve, and good morning to everyone who is with us. Thank you so much for inviting me to talk to you about Social Security. My goal today is to help you learn enough so that you'll better understand how the timing of claims for different types of Social Security benefits, including retirement, dependent, and survivor benefits, as well as SSI benefits, can impact positively and negatively the cumulative household benefit that special needs families can expect to receive over their anticipated lifetimes. Unfortunately, most of my brethren in the Social Security bar are not so well versed on this. That's because nearly 100% of their time is devoted to disability claims. And you will be learning more about these types of claims later on today. But disability benefits account for only 15% of the claims paid by the Social Security Administration. When and which benefits are claimed can impact the total benefits special needs families may be eligible to receive, both positively as well as negatively, depending upon the timing of their claims. So it is important for you to understand how these benefits coordinate with each other so you can provide guidance to your clients, as well as for those families that are listening in, as to how they can prepare themselves regarding as to when they should claim these benefits in order to maximize the benefits that they can expect to receive over their anticipated lifetimes. In this session, I will explain the differences between insured benefits under Title II of the Social Security Act and SSI, the means-tested benefit under Title 16 of the Social Security Act. I will explain the similarities and differences between two types of disability benefits under Title II and how these are similar to and different from SSI benefits, the means-tested benefit under Title 16. I will also explain what is required to prove entitlement to a disability benefit and how one can jeopardize his or her receipt of a disability benefit. Through it all, there is a definite sequence in terms of which benefits should be applied for first, if at all possible, in order to maximize the potential cumulative benefits that can flow to parents as well as to their children. And I will explain how to conceptualize that sequence. Now, a word about the format of this talk, which Steve alluded to. I have 154 slides. There is no way we are going to cover that many in today's presentation. However, they are all there to be used by you as a resource, a free resource to help you better understand this material. At best, what I can accomplish in 90 minutes is to alert you to issues. While you may not remember the details, hopefully you will remember the issues so that when you encounter a situation that triggers one of these issues, you will be better prepared to handle it, either by referring back to these materials, initiating further research, or contacting an advisor with experience in these issues. Finally, a word about what this presentation is not. It does not include a detailed review of the income and asset limitations imposed on SSI beneficiaries. To be sure, I will be addressing them briefly. It is not a review of special needs trust law. And most importantly, this should not be considered legal advice. Hence, this disclaimer. This is legalese that essentially says that every case has a unique set of facts that can be adequately addressed, that cannot be adequately addressed in the context of a webinar. While you may be able to draw certain conclusions about what you learned today, time does not permit coverage of all elements that might impact any given case. Agency rules number into the tens of thousands of pages. I only quote a few of those in this presentation. Again, today's presentation is to make you alert to certain issues. If you need legal advice, you should be careful about drawing conclusions about what you hear today without further inquiry. To highlight what I cover, I can provide some guidance for special needs families as to how to go about filing claims for Social Security benefits. I'm going to start with a case study. At the end of this presentation, I will address the answers to the case study that I now present. So here's the case study. You are approached by a couple in their 60s with a disabled child at age 23. Mostly they want to know when they should file for Social Security retirement benefits. How do you respond? David and Lisa Stone, ages 65 and 63 respectively, have come to you for advice. They have a son, Arthur, age 23, who has been diagnosed as being on the autism spectrum, and he may have other issues as well. He has what used to be termed high-functioning Asperger's syndrome. Arthur has had IEPs since 4th grade. He's very bright. However, even though he has an IQ of 130, he has slow processing, placing him in the 2nd percentile in the population. Arthur is easily agitated, frequently gets into arguments, engages in socially unacceptable talk. He has no self-filter, and he cannot focus for too long on an assigned task. Arthur graduated high school at age 18 and tried college, but was failing most of his classes by the end of the first year. When he was 22, in November 2018, a close family friend, gave him a job in his brokerage firm, earning $2,000 a month. At first, he worked as a receptionist and as a messenger boy, but he would get into arguments with customers, so he was put to work in the mailroom. But he took twice as long to do the work that a typical worker would require to perform the same tasks. He needed constant supervision and frequent retraining. After Arthur worked in the position for 14 months, that is to December of 2019, the family friend finally had to let him go. Arthur talks about finding a job, but spends most of his day reading and playing video games. He takes medication twice daily, but his parents must frequently remind him to take his meds, change his clothes, take showers, and so on. He's regularly seen by a therapist and a psychiatrist. David and Lisa know that their son will never be able to manage his money and perhaps not even his life. They have set up a special needs trust for their son. And additionally, Arthur's grandmother wants to leave a significant portion of her $300,000 estate to Arthur. David, who earns $150,000 a year, plans to retire next month when he reaches his full retirement age at age 66 in 2 months and would like to file for Social Security at that time. Lisa, who earns $35,000 a year, would like to continue to work, but could retire if she had to. Arthur's 23rd birthday was 2 months ago. That was actually a year ago, rather. Should David apply for retirement insurance benefits? David has only asked about retirement insurance benefits and has never considered any kind of disability benefit for Arthur. What do you say to David? So we are going to address that, and we're going to address these questions at the end of the talk. Should Arthur apply for SSI or CDB, both or neither one? And does it matter for which he applies first? What problems, if any, will Arthur have applying for CDB? That's Children's Disability Benefits. Will Arthur qualify for a disability insurance benefit? That's DIB. And when should David apply for benefits? Are there any concerns with respect to grandma's desire to leave a portion of her estate to Arthur? So all of these questions we're going to consider later on, but you should be thinking about them as we go through the talk today. So there are 4 types of benefits to keep in mind for this talk. There is RIB, DIB, CDB, and SSI. Although today's presentation, primarily the disability benefits available to children, you should be aware that the benefits paid to children account for only 5.4% of all benefits paid. This includes minor children as well as disabled adult children. And of all the Title II benefits paid, approximately 2/3 of those are paid to minors and those over age 18 but under age 19 and still in high school. That leaves only about 1/3 of that 5.4% that you see on the slide here to be paid to disabled adult children. That's approximately 1.1 million children. As I said, there are really 4 types of benefits to keep in mind for this talk: retirement insurance benefits, disability insurance benefits, children's disability benefits, and SSI. Retirement insurance benefits is what a parent receives as a retirement benefit on his or her own work record. The remaining 3 are different types of disability benefits. DIB and CDB are available under Title II and are insured benefits. DIB refers to the disability benefits that one receives on his or her own earnings record. Children's disability benefits, CDB, are available on the earnings record of a parent. SSI is available to minor as well as to disabled adult children. A beneficiary may be eligible for all 3 of these types of disability benefits. However, it can be a juggling act to time the claims for these benefits just right so that no benefit is jeopardized and household benefits can be maximized. This slide helps you to understand what benefits are available to a disabled child depending upon whether or not the child is a minor. There are really 2 categories, broad categories of benefits. There are the Title II benefits, which are insured benefits, and there's the SSI benefit, which is a means-tested benefit. So for a child who's under the age of 18, a Title II benefit is available, but only if the parent is the parent is insured and either retired, disabled, meaning that they've applied for and receive a disability benefit under Title II of the Social Security Act, or if the parent is deceased. A disabled child who is a minor will not be eligible to receive a Title II benefit unless one of these circumstances are present. And then it doesn't matter if the child is disabled or not, because the child is a minor, the child will get a benefit. However, a disabled child who is a minor can receive SSI, but only if the entire family's asset and income limitations are met. That means that the if it's a dual parent household, there's a $3,000 limit. If it's a single parent household, there's a $2,000 limit, asset limit. And in addition, there are income limitations as well. So a family may have a disabled child, but will be ineligible for any benefit for that child because the child is under the age of 18 or the age of 19 if a student, and therefore won't qualify for Title II benefits. And the family may have assets in excess of the asset limitation such that it would preclude entitlement to SSI. And that is because the family's assets are deemed to the child. On the other hand, if a child is at age 18 or above, benefits are available under Title II. If the child is still in high school and not disabled and under age 19, the children's insurance benefit is payable to that child. If the child, on the other hand, is no longer still in a high school, but is disabled, the child will be eligible to receive SSI benefits because at that point in time, there is no longer any family deeming to the child. If the parent is disabled, retired, or deceased, that child would also be eligible for a children's disability benefit, which we're going to discuss in greater detail shortly. This slide helps to understand what benefits we are talking about under which title of the Act. So there are cash benefits and there are health benefits. And in so many cases, what is most important are the health benefits. That's the holy grail. There are many fortunate families for whom the monthly benefit, the monthly cash benefit, is not all that, it's not of great concern. But they're really interested in enabling their disabled child to qualify for a health benefit. So if a child qualifies for a benefit under Title II, that child, after a 24-month waiting period, will become eligible for Medicare, which is a benefit under Title 18 of the Social Security Act. On the other hand, if the child qualifies for an SSI benefit, the child will also then qualify for Medicaid. Now, there are two different types of states, and I neglected to look up before the talk which one California fits into. There are 1634 states and there's 209B states. So 34 states are 1630, that's section 1634 of the Social Security Act, in which if a child qualifies, if an individual qualifies for SSI, they automatically qualify for Medicaid. In 209B states, states have their own criteria for qualifying for Medicaid once an individual has qualified for SSI. But in either event, their child most likely will qualify for Medicaid. So that's the holy grail. The SSI benefit itself is relatively modest. It's only currently at $783 a month for a single individual before any reductions. On the other hand, the benefits a child might be eligible to receive under Title II could be larger. And that is because the children's disability benefit that a child might be eligible to receive on the earnings record of a parent is based on that earnings record. So if the parent is a high wage earner, then the child is going to qualify for a children's disability benefit that's 50% of what is called the primary insurance amount of the parent. The primary insurance amount is not necessarily the benefit that's paid to the parent. Rather, it is what would have been paid to the parent if the parent filed a claim at his or her own full retirement age. If the parent files a claim for retirement benefits before full retirement age, that benefit will be reduced. On the other hand, the children's disability benefit will not be reduced on account of the parent's early claiming, because remember, the amount of the children's disability benefit is tied to the parent's primary insurance amount, which does not change regardless of when the parent applies for a benefit. Conversely, if the parent delays a claim for retirement benefits to beyond full retirement age, the parent is going to earn what are called delayed retirement credits that increase the retirement insurance benefit at the rate of 2/3% per month for each month of delay. Thus, a parent who files for retirement at age 70, who attains full retirement age at age 67, will experience a 24% increase in the retirement benefit. But at the same time, however, the children's disability benefit does not get increased. It remains the same. It still is based on the primary insurance amount, regardless of when the parent files a claim. Now, there are 3 types of disability benefits under Title II, and they are collectively referred to as SSDI. And one thing I'm going to try and do today is to get you all to stop referring to a disability benefit under Title II as SSDI. And the reason for that is it's difficult to know which benefit you're talking about except from context. But if you actually use the benefit name, then the other party will know instantly what you are referring to. So SSDI, Social Security Disability Insurance, refers to 3 different types of disability benefits under Title II. There's disability insurance benefits, which is the benefit payable to an individual on his or her own work record. There's also children's disability benefits, which are payable to a disabled individual on the earnings record of a parent. And then finally, there is a benefit that we're not going to be discussing at all today, and that's the disability widow's benefit. That is the benefit payable to a disabled widow who is at least age 50. Ordinarily, widows' insurance benefits are not payable until age 60. And that is the remaining item on the screen, the WIB, to which I refer to. So I've listed here all the types of benefits under Title II. There's a few others that are not listed here, like a parent's benefit. If you have aging parents living in the household with an insured retiree, those parents can get a benefit. In addition, if an individual has a spouse that dies and the individual is a widow or widower and they are below age 60, they may still be entitled to a benefit called a mother's or father's benefit if they have in their care a disabled child or a minor child. So take the family, you have a couple in their 30s, and the father dies of a heart attack. So you have a young widow, and they have 3 minor children. That young widow will be able to receive a mother's benefit on the earnings record of her deceased spouse, regardless of whether those children are disabled or not, because they are all minors. On the other end, and that mother's benefit will end when the youngest of those children reaches age 16. Now, the child himself or herself will continue to receive a children's insurance benefit until reaching age 18 or age 19 if they are still in high school. However, if the child is disabled, then at age 16, there will be a determination on their disability. And that's the rare circumstance where you will have a disability determination under Title II before the child reaches age 18. And that is only because they have a parent who is a young widow or widower receiving what is called a spousal in care benefit. That spousal in care benefit is 50%, or rather 75. I go back here for a moment. The spousal in care benefit would be payable to a spouse if they had a disabled child over the age of 18. But if you have a widow or widower, as I said, the benefit is called a mother's benefit or a father's benefit. And like the spousal and care benefit, it's payable because they have in their care either a minor child or a disabled adult child. So if a minor child is about to reach age 16, once that child reaches age 16, the mother in care benefit or the father in care benefit will disappear unless that child is disabled. And that is why that child will have a disability determination even before reaching age 18 in that circumstance. On the other hand, if the surviving mom or dad is working such that their mother in care benefit or father in care benefit is reduced to zero because of their high earnings, then there will not be any need to have a disability determination for that child at age 16. However, once the child is about to reach age 18, the child, because they have a deceased parent, will be subject to an age 18 redetermination. And we're going to talk about that later on in the talk, because now the child will become eligible for a children's disability benefit on the record of the deceased parent. The amount payable in that circumstance, by the way, is not 50% of the primary insurance amount. It's going to be 75% of the primary insurance amount. And that is because the parent is deceased. On the other hand, if that couple survive, if both parents are alive, when the child who is disabled reaches age 18, there will be an age 18 redetermination, but at that point in time, the child will now be able to only qualify for SSI because neither parent is deceased and neither parent has yet applied for or is receiving disability or retirement benefits. So that age 18 redetermination is going to now assess that child's disability on the basis of the adult disability criteria rather than the children's disability criteria. And the differences between the two are something that we will get into a little bit later. Okay. So it is possible for a disabled child who is age 18 or over to receive all three types of disability benefits that I've discussed about. They could receive a disability insurance benefit because they're already insured for disability on their own earnings record. At young ages, all one needs to be insured are 4 quarters of cover, or 6 quarters of coverage, not 4, 6 quarters of coverage. And one earns a quarter of coverage by earning over a small amount. It's currently between $1,000 and $2,000 at this point in time. That child could also be receiving a children's disability benefit if they have a parent who is retired and receiving retirement insurance benefits, disabled, or deceased. And of course, the child may also be eligible for the SSI benefit. Timing here is tricky because the SSI benefit is only $783. What happens if the child also qualifies at the exact same time for a children's disability benefit that is higher than the SSI benefit? If the SSI benefits are reduced dollar for dollar for unearned income received by the SSI beneficiary after the first $20 of unearned income. Thus, any individual who qualifies for a children's disability benefit that is higher than $783 plus $20, that's a total of $803, will not qualify for SSI. However, in the circumstance where the person applies simultaneously for SSI and CDB, the agency will award the SSI first if the disability qualifications are met. So you might have thought that because the awards are simultaneous, the child would never qualify for SSI. That's not true if the claims are submitted simultaneously. And there are two reasons for that. First, let's say someone applies for SSI and CDB in this month, in November. So the award for SSI will begin with the payment for December, which is received in December, because if one qualifies for SSI at the time they apply, the first benefit payment under the rules will be for the following month. And so they receive the December benefit in December. On the other hand, if they simultaneously qualify for children's disability benefits, the Title II benefit under Title II of the Act, the CDB benefit, will be payable for December in January, because Title II benefits are always received 1 month in arrears. So the disabled beneficiary receives SSI first and then CDB. And this is really critical. Why? Because if an individual qualifies for SSI, you recall that I said the individual will qualify for Medicaid. So if they receive the SSI first and they receive Medicaid, and then they later qualify for a higher CDB benefit that wipes out the SSI benefit, there is a special federal statute that guarantees continued receipt of the Medicaid benefit if the only reason for disqualifying the individual for Medicaid is the receipt of a higher children's disability benefit. So the individual who qualifies in November for SSI because they receive, because they are disabled and they don't have assets over 2,000, they'll get a benefit of $783 unreduced. It can be reduced for other reasons, which we are not going to discuss here. The individual who, if that same individual qualifies for CDB, it will first be paid in January, even though what's being paid is the December benefit. That means that starting in December, they will also qualify for Medicaid. Now, what happens in January when they get a children's disability benefit that's, say, $1,800 or $17, let's say they get a benefit that's even $1,000, that's well over the SSI benefit. They will be disqualified from receiving SSI, but their Medicaid entitlement will continue. And in addition, the clock will start running on their entitlement to Medicare. There is a 24-month waiting period for entitlement to Medicare. So they will not be eligible for Medicare in this scenario until January of, rather December of 2022. And that's because their first month of entitlement for children's disability benefits was December of 2020 in this scenario. So there are a number of law references that I have put for the different programs on each of these pages that you can refer to. There are 3 levels of authority. There's the statutes, which are denominated by SSA. There's also the regulations, which appear, the Social Security regs appear in Title 20 of the Codified Federal Regulations, that's CFR, and they appear in the sections that I've indicated, parts 404, as well as parts 416 of Title 20. And then there are the POMs. POM stands for Program Operation Manual System. These are the internal agency rules. They are available on the internet. These go into excruciating detail on every aspect of the Social Security program. The disability POMs are in the DI section. The SSI POMs are in the SS and the SI section, and they go into thousands and thousands of pages, tens of thousands of pages, if printed out. These agency rules do not have the force of law, but the courts give deference to them because they do represent official agency interpretation of the governing statutes and regulations. And under various court cases, the agency does receive certain deference from the courts as a result, in terms of the agency's interpretation of the statutes and regs as expressed in the POMs. The POMs, however, are not law, and if it can be shown that the agency's interpretation is contrary to law, the POMs can be overruled by the courts. And here you have it. This is your first CLE code, 5320.
Okay. And this is probably a good time to ask a couple of questions and make some observations. One is we're getting a lot of questions here and observations about California. By the way, we have a lot of folks that are not from California. They actually do exist, and they're watching this as well. California is a categorical eligible state, which means that if you get $1 of SSI, you get we call it Medi-Cal because we just got to be different. Other states call it Medicaid, and Massachusetts calls it something altogether different. It's all Medicaid. Just to let you know, that's true. The other observation I'll make as Avi goes through this, you might notice on the left, there's a column, and I think this is brilliant. I probably will steal this myself, but you might notice as he goes down his list here, there's a little arrow that tells you where he is and where he's going. So for those of you that are asking questions about how do you determine whether or not my child is disabled, he's going to get to it, okay? Just to let you know.
Okay, so let's move on and now talk generally about children's insurance benefits and children's disability benefits. So the general rule is that a minor or disabled adult child of an individual entitled to retirement or disability benefits or deceased individual fully or currently insured is the one who is eligible to receive a children's insurance benefit. There are four primary considerations: the insured status of the wage earner, the relationship of the claimant to the wage earner, the age of the child, and that child's dependency on the wage earner. So we're going to look at each one of these briefly. The first consideration, in order to qualify for a children's disability benefit, the parent has to be insured. If the parent is not insured, then we have no business talking about children's disability benefits. So for most workers, the parent, in order to be fully insured, must have 40 quarters of coverage. That's 10 years, and it insures the individual for life. So if the individual worked from age 32 to 42 and never worked another day in their life, they would still be covered under the Social Security Act. If the parent dies or becomes disabled prior to age 62, then the 40 quarter requirement can be modified depending upon the age at which the parent dies. For example, if you had a couple, say age 25, and they had two minor children, and then the dad dies tragically in an automobile accident. Well, at 25, dad would not necessarily have 10 quarters of coverage. I mean, it's possible. I mean, dad could have worked as a teenager, but more often than not, dad won't have 4 quarters of coverage. But at age 25, if under this rule where you count the number of years after age 21 and stop with the year before death or disability, dad would have 22, 23, that dad would have 3 years of coverage. That's 12 quarters of coverage. And he only needs 1 quarter for each year in that circumstance he only needed 3/4 of coverage at age 25, and if he's worked since 22, he could have as many as 12. A minimum of 6, however, is required. So the 3/4 of coverage won't do it by itself. Dad at age 25, who tragically dies, would need to have worked for at least a year and a half. There are special rules governing how many quarters of coverage an individual needs if they're filing for a disability insurance benefit. So in addition to being insured generally, the individual also has to be currently insured, meaning that they have to have at least 20 quarters of coverage during the 40-quarter period ending with the quarter in which disability began. But for those who are disabled and they are younger than age 31, then the requirement is that they must have earned quarters of coverage for at least half the period, beginning with the quarter after the quarter in which the claimant attained age 21 and ending with the quarter in which he or she became disabled. Still, a minimum of 6 quarters are required. So what that then means is that an individual who is a young adult could qualify for a disability insurance benefits for at least 6 quarters of coverage, a year and a half of earnings. That's all that is necessary. And then there are special rules for individuals for whom the reason for their disability is on account of blindness. So remember, there are 4 issues to consider here. We've briefly considered the insured status issue. There's also the child status. Who is a child? And these categories reflect who might qualify as a child. And in fact, a grandchild might qualify as a child. You might have mom or dad who are not insured, but grandma might be insured. And there are certain circumstances where that grandchild could qualify on the earnings record of a grandparent, even if that grandchild has not been adopted. In that circumstance, the parents would have to be deceased, and there are some other qualifications. The point to remember here is that in certain limited circumstances, an individual may qualify for a children's disability benefit on the account of a grandparent. Ordinarily, in the usual circumstance, if you have a natural child or a legally adopted child, dependency is presumed, and of course, that individual would be a child. And that does move us on to the third issue, which is the age of the child. And again, we've already discussed this. The child who is under age 18 will not qualify for a children's disability benefit, but they may qualify for a children's insurance benefit if the parent has been deceased or is retired or disabled. Also, very important to consider, an individual who is applying for a children's disability benefit must be unmarried. If that child is married, that will disqualify them for a children's disability benefit, and a subsequent divorce will not re-entitle them. The only way a child who has married will ever qualify for a children's disability benefit is if that marriage is annulled or voided in some way. Divorce in and of itself will not requalify a child who has been disqualified because of marriage. There are certain limited circumstances where marriage will be okay. That includes a situation where the person who is the other spouse, the one who is being married, is him or herself also receiving Social Security benefits, but not a Social Security children's disability benefit. So I've cited the reg here if you want to look that up in greater detail.
Okay, if we could just pause for a minute. This comes up
Yes.
all the time. We get this question, so this may bear repeating. The incidence of divorce for families with disabled children is astronomical, right? So what does divorce of the parents do as far as the child's eligibility? I know you covered this, but I know it's worth repeating.
Okay, so if the parents are divorced, that's not what I'm talking about here.
Yeah.
I'm talking about marriage of the disabled child, okay? If parents are divorced, that doesn't change anything in terms of the child's entitlement to a children's disability benefit on the account of either parent. And even if let's say you have divorced parents and child continues to live with mom, dad does not have custody, but dad is a natural parent. And because dad is a natural parent, the child's dependency on dad is presumed. So there is no need to go any further than that.
So the important part of that is it's an entitlement. It's not a gift. So
yes.
Even if dad or mom never paid 1 cent of child support, that's not what we're talking about.
Correct.
Okay.
And then we get into, all sorts of issues. What if dad was actually previously married and never got divorced? And so the marriage is not valid in the first place, but it might be a putative marriage. It's a legal concept. So we don't have time to go into all these details, but you should know that if there are issues there could be issues with marriage if it's not the typical situation, but they may be overcome once we get down into the weeds. Okay. And that alludes, of course, to the dependency requirement. And as I said earlier, in the usual circumstance, a natural or adoptive parent is presumed to have their children are it's presumed that their children are legally dependent on them. And dependency can be at the time of the application, at the time of death, the time the insured becomes disabled, at the time the insured becomes entitled to benefits. And dependency is usually deemed except when when a child is legally adopted by someone other than the insured during the insured's lifetime. That adoption cannot have cut off inheritance rights, and the insured must have been living with or provided at least one half support. And again, this gets down into the weeds that could be an hour seminar just on its own merits. So we're not going to go further into.
And the good news for those that are watching, this is recorded and it will be up as soon as we can. So if you can go back and listen to this again, and I know I'm probably going to listen to it about a half a dozen times. So there you go.
Okay. Now, when we're talking about children's disability benefits, sometimes people refer to them as DAC benefits. DAC refers to disabled adult child. In the statute, it refers to it as a children's disability benefit, not as a DAC benefit, but they're one and the same. I will be referring to it as CDB throughout this talk. So a disabled child under the age of 18 is going to be eligible for children's insurance benefits like any other child if the parent is retired, disabled, or deceased. Whereas a disabled child over 18 is eligible for CDB if the parent upon whom the child is dependent is retired, disabled, or deceased. And that child, as we said before, I can't emphasize it enough, that child must be unmarried and again, dependent upon the primary wage earner. And then finally, and this is an extremely important point, if you don't get anything else out of today's session, I want you to remember this, which is the issues surrounding the continuity requirement. Social Security policy, and I emphasize policy, not law, Social Security policy, as stated in the POMS, states that an applicant for a children's disability benefit must show continuous disability from prior to age 22. And that means they must show that they have been disabled from at least 2 days before the anniversary of their 22nd birthday. And that is because if someone is not disabled at all and then is struck in an automobile accident on their 22nd birthday, or even the day before their 22nd birthday, such that that date is the day that they become disabled, they will not qualify for a children's disability benefit. You have to be disabled before you reach age 22, and you do not reach age 22 on your 22nd birthday in the Social Security world. You reach age 22 on the day before the anniversary of the day of your birth. And that's true for all types of benefits. If you're born on the first of the month, you reach age 62 in the prior month. And that's when you will first become eligible for a retirement benefit. So an individual must become disabled at least by the second day before they reach age 22. Now, if that individual applies for a children's disability benefit at age 30, and they've had a couple of jobs, maybe they've had a dozen jobs, each of which has lasted for a year, and they have had earnings over what is called the substantial gainful activity threshold, and we'll talk about that shortly. They will be fine. They will not be eligible for a children's disability benefit based on Social Security standards. That's because the agency maintains that you have to show disability continuously from before age 22. And if an individual has engaged in what is called substantial gainful activity after age 22, that presumably would disqualify them from receiving a children's disability benefit. Or does it? This continuous disability requirement is not stated anywhere in the statute and is not stated anywhere in the regulations. Nowhere. It only is stated in the POMS. And I've indicated the POMS provision right here. It says that the field office must issue a denial if the field office can't establish onset prior to age 22 there's been substantial, or if there has been substantial gainful activity after age 22. And in that circumstance, the field office is instructed to deny the claim. But if it's not in the statute and it's not in the regs, where does it come from? Case law. And why does it come from case law? It comes from case law because some attorney representing the agency had a brilliant idea that disability, if an individual has to be disabled before age 22 in order to qualify for CDB, let's say they have to qualify for disability throughout the entire time frame. They made the argument, and the district court bought it lock, stock, and barrel without any discussion. The earliest case I could find at the appellate level is a Sixth Circuit case called Futternick. And again, there's very little discussion in the case about it. It cites a bunch of district court opinions, none of which adequately discuss this requirement. One of the first major discussions does not come from a Social Security case, but from a black lung case, KIDA. And that actually examined the legislative history. And they determined from the legislative history that the continuity requirement, even though it was not stated in the law, was implied. That's what the legislators intended. So I've looked at that legislative history, and it does express what some legislators thought. I would argue it doesn't necessarily reflect what all legislators thought. And I believe this is an issue that's ripe to be challenged in the proper case. And why? because the courts are now filled with just a plethora of conservative judges. And conservative judges as a group typically do not like to look at legislative history to derive the meaning of a statute. They tend to be more interested in what is called the originalist doctrine or the textual doctrine. You can't look beyond the text of the case. And liberals are all up in arms over this because liberals tend to believe that this is a made-up doctrine, and it is, that the judges should not be using. But there is a flip side here, and it can also be used to the advantage of those who might otherwise see doom and gloom with the appointment of so many conservative jurists, because these same jurists might be more willing to entertain an argument that there's no continuity requirement for CDB. It's not in the statute, it's not in the text. It's only derived from legislative history, and that history, I believe, is questionable. And so I'm throwing it out there that if someone, in the right case, this might be something that could be challenged, but you would have to be prepared to go to federal appellate court on this, because no agency clerk is going to accept an argument based on how case law should be interpreted. If an individual qualifies for a children's disability benefit, there's no 5-month waiting period. That is what is typical for a disability insurance benefits beneficiary. One can receive up to 6 months retroactive benefits if you apply for a children's disability benefit. So if an individual is applying for a CDB, let's say at age 22, let's say dad retired when the child was at age 19, let's say further they didn't know about CDB, dad applied for his benefit, and on the benefit application, dad would have been asked about having a disabled child. And if dad puts down on the application that he had a disabled child and the agency did not pursue a CDB claim, then the benefit application for CDB 2 or even 20 years later could be retroactive to the date of the application submitted by dad for retirement benefits. However, the application itself must reference the disabled child. If that application does not reference the disabled child, it's going to be very difficult to use dad's application for retirement as a protected filing date for the children's disability benefit. In that case, the child can only go back retroactively 6 months in order to try and recoup some of those lost benefits. Under the continuity requirement, one should also consider, even if the child has engaged in substantial gainful activity, that work can be overcome in certain circumstances. It could be argued that these were unsuccessful work attempts and that the child didn't really hold down a job any longer than 3 months at a time. Or it could be that the work was done in a sheltered workshop or under circumstances that are like a sheltered workshop. I had a client whose son at age 30 had worked for a number of years in a friend's brokerage firm. And they were earning really good money, between $20,000 and $30,000 a year. But it was a friend's firm, and the child was not performing well. The child was moved from position to position. The friend was doing this, out of kindness, because it was a really close family friend. It was not an acquaintance. And they wanted to help the child develop some self-esteem by working in a regular office and feeling important, by going downtown and working at the Mercantile Exchange here in Chicago. But in reality, the child had to be closely supervised. at various points, one of the employees was assigned to be a full-time supervisor for this individual. Child was not working at market rates. They were earning market rates, but their performance didn't reflect what they should have been paid had they been paid for what they were actually doing. And what was happening here is that the child was receiving a subsidy. And that's what I referred to at the bottom of this page. And there are certain rules involved when one is receiving a subsidy. And in that case, the father's friend was asked to write a letter to Social Security indicating how much of what was being paid was a subsidy. And if what was being paid as a subsidy was greater than, or well, let's put it this way: if you took away the subsidy, and if what the child was being paid at for what they were actually performing was less than the substantial gainful activity amount, then even though the child took home pay that was well over as the SGA limit, that subsidy could in turn result in a determination that the child was not actually earning at the SGA limit, and those earnings would therefore not disqualify the child for a children's disability benefit. So this is very important. Now, the Social Security forms do not contemplate a subsidy that is greater than 50%. But merely because the forms don't contemplate it doesn't mean you can't allege it if in fact that is the case. It can also happen that even though the child has high earnings, the earnings can be reduced what are called income-related work expenses, or IRWEs for short, IRWE. These IRWEs could be anything from meds that the child has to be on in order to be able to maintain sanity in order to work, to a personal trainer that the child sees, or a job coach that the child sees, and the cost for that. I had a client who went to a gym every day to work out their stresses, and they had a personal trainer, very expensive, not covered by Medicare, not covered by Medicaid, but the doctor wrote a prescription on the prescription pad for this personal trainer. We submitted it to Social Security, and the cost of that personal trainer helped to bring down considerably what the countable wages were for that child, such that their wages were below the SGA limit. And by the way, it also brought down the countable wages for SSI purposes as well. Now we're going to look at what it takes to prove disability. I'm going to briefly refer to some of the points that you should remember, but I'm not going to go through this in great detail. That is a lecture in and of itself. Disability is the inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, which has lasted or can be expected to last for a continuous period of not less than 12 months. So it's not the underlying medical impairment that is required to last 12 months. It's the inability to engage in substantial gainful activity by reason of the impairment. And that's an important point to remember. So I'm going to repeat it. It's not the diagnosis that establishes the qualification. It is the functional incapacity as a result of the diagnosis that will qualify an individual for disability benefits. Very important to remember that. Now, there are special rules for individuals who are claiming disability under the age of 18. The whole disability program is based on the idea that a person can't work because of their disability. But if the individual is under 18, we don't expect them to work. You know, this is not Dickensian England. You know, we don't put, 10 and 12-year-olds to work in the factory. So how do we then determine what disability is for such an individual? So for these individuals, the definition is slightly modified. It's not that they are unable to engage in substantial gainful activity for a period of at least 12 months. Rather, an individual under age 18 is disabled for SSI purposes if, quote, that individual has a medically determinable physical or mental impairment which results in marked and severe functional limitations and which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. Again, it's not the diagnosis, but in this case, it's the severity of the functional limitation. Functional limitations are graded on a 5-point scale that goes from none to mild to moderate to marked to severe. And each of these points on the scale are defined in the regs. And if an individual is going to qualify on this basis, they have to at least have marked or severe limitations, not just mild or moderate. However, if this child who's young, let's say age 16, is working and is earning at the SGA level, meaning that they have earnings over, I think the SGA level is currently $13.10 a month. I have it in the slides later on, so we don't have to guess. If that child is earning over that limit, they can't be disabled under the Act. The child could be severely impaired. An adult could be severely impaired. I had a fellow student in law school who was a quadriplegic. Later, that individual went on to become a juvenile court judge, earning well over the SGA limit. He could not qualify for disability so long as he was earning over the SGA limit, even though automatically a quadriplegic would otherwise qualify for benefits because they would be considered to be so functionally impaired that they would qualify. But if you're earning over SGA, you cannot receive a disability benefit. So the determination of disability is a 5-step process for adults. The first question is, does the individual engage in substantial gainful activity? And here I do have it. It is 1310. Now, if the individual is blind, there is a higher amount that will qualify the individual for disability, and that's 21. It'll be 2190 in 2021. The current limit, I apologize, is 1260, not 1310. 1310 is the 2021 limit. 1260 is the 2020 limit. And these are limits for non-blind individuals. The second question, so if an individual comes to me and says they want to apply for disability and they're still working, I say, come back to me when you're not working. It will not work for the individual to be working and apply for disability at the same time. Now, if the individual is self-employed, there are special rules, and we're not going to go into that here. Just know that there are special rules. The second question is the impairment severe? So that means an individual has to have more than just a headache. Now, migraine headaches are a different story, but it can't be a hangnail, a splinter, something that is just mild. There has to be a severity to the impairment. The third step is to ask whether or not the individual meets or equals one of the impairments listed in 20 CFR Part 404, Subpart P, Appendix 1. That's called the listing of impairments. You're going to hear that over and over again, the listing of impairments, and this is where it's found. Now, there are special listings for minor children, which refer, again, only to SSI claimants, because remember, minor children, whether they are disabled or not, will qualify for a children's insurance benefit if the parent is retired, disabled, or deceased. Step 3 of the disability determination process is the first step at which an individual could be deemed to be disabled and qualify for a disability benefit. And again, keep in mind that these rules equally apply for claimants for a children's disability benefit, for a disability insurance benefit on their own earnings record, and for SSI. All three of these have the same disability determination process. And at step 3, if an individual has certain diagnoses and they demonstrate functional limitations as expressed in the listing of impairments, they will qualify at step 3. But what if they don't meet or equal one of these impairments? So meeting, and I'm going to explain here, meeting an impairment means that you fully satisfy the requirements as stated in the listing of impairments. Equaling an impairment means that you don't necessarily fully meet, but you do have characteristics that equal what is written in the listing of impairments. For example, an individual might have a heart problem, and they might have undergone certain heart exams and certain heart tests, and they're functioning on those tests might be at a level where they would qualify for benefits. However, maybe the individual was administered a different test, one that is not in the listing of impairments, but is equally acceptable to specialists in the field. If the test result can be correlated with the test that's written in the regs, they will be deemed to equal an impairment rather than meeting an impairment. And this has consequences for mental impairments as well, since there are so many different types of tests that a mentally impaired claimant might have been administered. They might have been administered a test that's not stated in the regs, but the results can be correlated with one that is. Now, if the individual does not meet or equal a reg, a listing in the listing of impairments, then we move on to step 4. Does that individual have what is called the residual functional capacity to engage in past relevant work? And capacity can be measured both in terms of physical impairments, in terms of how much you can carry, how long you can stand on your feet, how long you can walk, and so forth. And they can also be measured in terms of mental capacities. And there's 4 domains of functionality. And the residual functional capacity will measure how one performs in several of those domains. And then finally, if the individual does not have any past relevant work, then we move on to step 5. And that is the question where if it is an individual unable to perform, if they can't perform their past relevant work, are they able to perform work for which there are a significant number of jobs in the national economy? And this is where an individual's combination of impairments might come into play, and where their particular limitations might also come into play, because there might not be a significant number of jobs for individuals who cannot tolerate bright lights, who may not be able to work with other people. They may not get along with supervisors. They can't work, with the public. They might need frequent breaks during the day, rest breaks. That such an individual might not meet or equal an impairment in the listing of impairments, but an individual that needs 7 or 8 breaks during the day might not qualify for any job, because there are few jobs that are going to permit someone to take that many breaks. So this is the 5-step analysis. I go into greater detail on these slides. I'm not going to go through them now, except here, where I'm going to talk about the mental impairment listings. They are listed in section 12 of the list of impairments. And many of the impairments in the listing of impairments have what are called A, B, and C criteria. The A criteria relate to medical findings. The B and C criteria describe impairment-related functional limitations. And most circumstances, an individual must fulfill A criteria as well as B or C. But in certain listings, there is no C criteria, and there will only be A or B. The C criteria appear in these specific listings. The B criteria relate to 4 areas of functionality. And those areas of functionality are the ability to understand, remember, or apply information, the capacity to interact with others, the capacity to maintain concentration, persistence, or pace, and the ability to adapt or manage oneself. The last area used to be called activities of daily living, but it has been broadened to include this adapt or manage oneself limitations. And this is what we generally refer to as executive functioning. So an individual has to show, under the old rules, 2 of the following. Under the new rules, you have to basically show marked or severe limitations in at least 2 of these 4 areas. Extreme in 1 or marked limitation in 2 of those 4 areas in order to qualify for benefits. So this will be of particular interest to those with children who are on the autism spectrum. I'm going to move on because it's getting late. You can look at these areas at leisure. The disability rule under Title 16 for those who are disabled is exactly the same as it is for those who are under 18 or over 18 and applying for CDB. Although here we have its functional limitation, and that's the difference, that there's no substantial gainful activity requirement as there is for those who are age 18 and over. And for individuals under age 18 applying for disability under SSI, there's only 3 steps. And it's, again, looking to see if the individual is performing at the SGA level, if the claimant has impairment is severe, and if it meets or equals the severity set forth in the listing of impairments. There's no steps 4 or 5. There is a difference under age 18. The agency will look at least at 6 domains of functionality, not just the 4 that I mentioned previously. And these 6 domains are defined in the regs at Reg 416.926A. Guidance for anyone who is applying for disability benefit for children should look at Social Security rulings. I didn't mention them previously, but these are basically opinion letters written by the Social Security Administration. These are outside of the POMs, but they are available online. And these SSRs actually provide a pathway for proving disability for a child. I previously talked about age 18 redeterminations and when they take place. And one should look at SSR 11-2P for guidance in this area. When there is an age 18 determination, the adult rules apply. And if a child does not meet or equal listing at step 3, then they have to be found disabled at step 5 of the sequential evaluation process. I am just going to briefly mention the 4 steps or 5 steps for the disability appeals and application process. So there's an initial application, and then if one is denied at that level, you can ask for a reconsideration of the claim. Initially, the claim is going to be decided by a state disability determination service with which the Social Security Administration contracts. And then if it's denied and a request for reconsideration is filed, then it goes to someone in the local field office to consider. If denied at that stage, an individual can appeal for a hearing before an administrative law judge. And in each case, you have 60 days from the date of the notice to appeal, but an additional 5 days are added for presumed time that it takes for you to receive mail. If you receive notice beyond that 5-day presumed period, you might be able to challenge the 5-day presumption, but you would probably need to show office procedures that you use all the time to document when an item is received. If an individual's claim is denied at the administrative hearing level, then you have a right of appeal to the Appeals Council in Baltimore, Maryland. And then finally, if denied by the Appeals Council, then and only then can you appeal a claim to federal district court. And then each of these steps along the way, there's the 60-day appeal period plus 5 days for mail. In rare circumstances, if you've blown the appeals period, you might be able to reopen. Generally, you can reopen a previously determined matter within 1 year for any good reason, and within 4 years if you can show good cause. The good cause limitation is 2 years for SSI claims. Now, look at this schematic. Hot off the press, was issued just a few months ago. It shows your likely success at each step along the way. 37% of all initial claims are allowed. But you have to keep in mind that this includes a lot of people who are applying on their own, who don't know what kind of evidence needs to be submitted. The agency allows about 13% of those who file for reconsideration. And then at the ALJ stage, that is the first place where you have the opportunity to really engage with an adjudicator back and forth who's examining the claim. It used to be, as recently as 2009, that 63% of all claims were awarded at the ALJ stage. In just 10 years, 11 years, this has now been reduced to 45%. That's not a fluke. It's been going down steadily. And it's been going down because over time, the agency has become a deny-em-all culture. And I say this to my clients, and I will say it to you. You might think that the Social Security Administration is here to be your friend, to help you receive the benefits you deserve. That's not true. And I'd be happy to engage one-on-one with any staff person at the agency on this topic. So I have no problem putting it out there on a recorded webinar. The culture at the Social Security Administration is to deny as many claims as possible. If a claim can be a disability claim, that is, if a disability claim can be denied, it is seen as a win. And if it can't be denied, that is a loss. The goal is to deny as many claims as can legally be done. There is a bias at the agency to deny disability claims. You need to understand that when you apply for disability benefits. They are not your friend. They are not there to help you. They are there to deny as many claims as they possibly can. And that can be seen in the increase in rate of denials. That can be seen at hearings where vocational experts lie all the time about the significant numbers of jobs that are available in the national economy. And when you ask these experts what's the basis for their numbers, they say my experience. But when you start to question them about their experience, you can be cut off by an ALJ, say, counselor, let's move on. But if you're an attorney and you're listening to this, you should attempt to question the VEs anyway, because you want to make the record, because you can't appeal what you haven't questioned, and therefore it's important to press VEs on this point. Social Security Administration is supposed to help you develop the record. ALJs are required to develop the record, meaning that they should be looking for all the medical evidence. But I've been told they only go back a year. So if you're trying to file a children's disability claim when your child is at age 30, they're not going to press and they're not going to look for the evidence from prior to age 22. They're only interested in evidence for the previous year. And if a medical provider doesn't provide the evidence, they're not going to issue a subpoena to that provider, even though they have the power to do so. So that is why the allowance rates have gone down from 63% to 45%. You can appeal to the Appeals Council, but only 1% of the claims are allowed at the Appeals Council, and only 22% were remanded in 2009, and that has gone down to 11% in 2019. If you are denied at the Appeals Council, you can appeal to Federal District Court where you have a decent shot. There is a number of claims that are remanded. That percentage is at 50% right now. What that means is your tax dollars are paying for federal district courts to remand cases that were wrongly decided at the agency level.
There is one real easy question here.
Yes.
What's a VE?
Oh, I apologize. A VE is a vocational expert.
Okay. By the way, for those of you that are watching here, this is going to be recorded. So if you end up having to drop off, you will be able to pick it up right where we left off. But we're plowing ahead, Avi.
Right. We're plowing ahead. And I have skipped through all of these slides that go into these 5 steps in greater detail. Now, let's look at disability benefits in terms of this schematic, comparing Title II versus SSI. For Title II eligibility, you're going to need a work record if you're applying for a DIB, or if you're applying on the earnings record of a parent, the parent is going to need a work record. SSI benefits are means tested, and they're limited to U.S. citizens or eligible aliens. There's no means test for a Title II benefit. So if Junior is receiving a children's disability benefit and is not receiving SSI, there's no asset limitation. Junior can receive a large inheritance. However, just because Junior can receive a large inheritance, that may not necessarily be what you want to have happen, because Junior may still qualify for Medi-Cal under other or for Medicaid in other states, even if the Junior is not qualifying for SSI. So you still have to be aware of asset limitations, even in cases where SSI is not being received and where it was never received. There is, in terms of income limits, for unearned income, there is no limit if someone is receiving CDB. But if someone is receiving SSI, the first $20 are disregarded, and then everything else is counted dollar for dollar, and it will reduce SSI benefits dollar for dollar. Now, again, even if your CDB child, if your child is receiving CDB and not receiving SSI, you don't need to be concerned about unearned income unless your child is also receiving Medicaid. Because remember, the rule at 1634C is that an individual who no longer qualifies for SSI will continue to receive Medicaid if the only reason for which they are not receiving SSI is because they receive CDB. Well, if that person who receives CDB receives a $100,000 inheritance from grandma, that could disqualify them for Medicaid, even if they were receiving SSI, because it would disqualify them for SSI. So you still have to be concerned about unearned income limits in order to maintain eligibility for Medicaid, even if SSI is no longer being received. Again, this continues the general comparison of Title II to SSI. The disability standard is the same for both, and I've mentioned that. In terms of an earned income limit, for SSI beneficiaries, I said it was 1810 in 2018. I neglected to update this. It's 1260 in the current year, and it's going up to 1310 for 2021. The SGA limits for an individual who is receiving SSI, the SGA limits are no longer at issue. Rather, we are looking to see what the individual earns in order to reduce their SSI benefit after the first $65. And then it's a $1 for $2 reduction for earnings over age 65. Okay, I'm going to move on here, except that the payment amount under Title II is dependent on the work record of the wage earner on whose account benefits are being paid. And that means that a disability beneficiary who has a short work record might actually be receiving a small disability insurance benefit in addition to the children's disability benefit. And if that children's disability benefit is low enough, they could also be receiving a small amount of SSI. And that's where you get the individual who's receiving 3 benefits in that Venn diagram I showed at the beginning of the talk.
Probably
SSI,
a question that we got here several times was, do you have to apply for one or the other? Here, if you're applying for, they might qualify for SSI and CDB and whatever. Is that one application, 2 applications?
Okay, so if you apply for SSI, you are presumed to apply for CDB and DIB as well. And the clerk is supposed to explore whether or not DIB and CDB is applicable in that case. But if the clerk does not, you should actively ask whether your child might qualify for CDB and DIB. Now, if your child has never worked, you know that your child is not going to be eligible for DIB, so there's no point in asking. And if you have not retired and you're not disabled and neither spouse is deceased, then you know that you're not going to qualify for a CD. Your child won't qualify for CDB. But if there's a question about it, ask. Conversely, if you apply for CDB, if your child rather applies for CDB, you will have to actively apply for SSI as well. The clerk is not going to spontaneously offer up SSI for your child. Now, the clerk might, but is not required to. And therefore, if you don't know what the amount of the CDB is, don't go into a Social Security. Well, right now, nobody can go into a Social Security office, but don't call up Social Security and say, I want to apply for CDB, and don't say anything about SSI. I mean, if you know that the CDB is going to be higher than 803 in 2020, then you will know then that SSI is going to be off the table. But if you don't know what the CDB benefit amount is, then you should also apply for SSI. And the agency will sort it out. So yeah, the answer is, if you apply for well, I would say the general answer is you should actively apply for all benefits that you believe the child might be entitled to, and not rely on the presumptions that the agency worker is supposed to operate under. That's really the best advice. Okay. So under Title II, a payment can be made to a child, but only as a dependent. So there's going to be a representative payee in that circumstance, and we'll talk about that later. SSI benefits cannot be paid to a child as a dependent, but the family might receive SSI, and they might also receive, welfare benefits. If the child is disabled, then the child can qualify for a Title II benefit if over the age of 18, if disability can be shown to have begun prior to age 22, and that child who is under 18 can qualify for SSI if the income and asset limitations are met. Okay, so how you prove the claim, you have to show disability. But before we go any further, I believe we are probably at a point in time where we should mention the second code. So that second code is 8840.
Great.
Okay, so now moving on. One should try and obtain a finding of disability prior to age 22, even if the benefit is low. And that is in order to preserve eligibility for children's disability benefit. So if you have a family where neither parent is retired, neither parent is disabled, neither parent is deceased, but the child is under age 22, it would be good to try and establish the child's disability by applying for SSI. But I understand that you may not want to do that in all cases. It may be that the child is high functioning, the child might be in college, and you might expect that the child will be able to find a job and go to work. And it could perhaps damage the child's self-esteem if you apply for disability prior to age 22. So a sensitive advisor has to take all that into consideration. But if you have a child who's profoundly disabled, there's no reason to wait. And even if you might think, well, I'm going to retire in a couple of years, why don't we just wait until I retire? We don't have to deal with the income and asset limitations of SSI. I would recommend against that strategy. And the reason I would recommend against it, excuse me, is by the time you retire, your child might be over age 22. Secondly, by getting a disability determination on the record before age 22, that is invaluable for proving CDB later on. Now, some of you might be jumping up and down and saying, well, my child qualified for SSI, in 2014, and I just tried applying for CDB, and they're telling me my child isn't disabled. So what's this about qualifying for SSI beforehand? Well, the reason why you are having problems now is because in 2017, the Social Security Administration changed the rules for qualifying for disability on the basis of a mental impairment. And in 2019, in January of 2019, Social Security issued a secret memo. It's secret because it was never published on the internet. It was not published at their website. It's not published to this day. It was an agency, it was an administrative message, 1810, which basically said that the agency should not allow disability claims if the basis for disability is based on a determination, of disability that was issued prior to January 17th of 2017. So as a result of that memo, and they said that individuals who are applying under a different program for disability after January 17th of 2017, those individuals' claims should be sent to the disability determination services like any other initial claim for disability benefits. And then the agency later codified this in the POMS under a new collateral estoppel rule. And as a result, even though the individual might have qualified for SSI prior to January 17th, 2017, a new claim for disability under Title II, a children's disability benefit claim, is going to be subjected to a brand new disability determination process. And because of the rules change, the agency says it doesn't have to use the old determination as a basis for allowing a new one. Rather, the agency can deny the new claim. And they have done so. And those claims are appealed. But that's only if your SSI allowance was before January 17th of 2017. For new claimants at this point in time, if you are awarded SSI at age 18 or 19, and then you apply at age, say, 22 for CDB, so long as there has not been a change in the criteria under which disability is determined for the disability, and you're applying under the same disability, then that subsequent SSI determination should operate collaterally to prevent or stop the agency from claiming that you're not disabled. It's really important to document everything while a child is young. Early intervention assessments, IEPs, school psychological tests, gather them up, don't throw them away. If your child is going to a physician, let's say your child is on the spectrum and sees a psychiatrist every 6 months, and the child is asked, "How are you doing?" And the child says, "Fine," or the parent says, "Well, they're doing fine." Don't say fine, because what's going to happen is that your doctor is going to write patient doing well, patient doing fine. And what happens at age 30 when the child gets all those medical records together and you submit them? You're going to see page after page of the doctor will renew the meds and says patient doing fine. Well, how do you think that's going to look to an adjudicator? They'll say, "Oh, the doctor is pushing meds, but they're doing fine." Doing fine means they're not disabled in the Social Security world. So if there are issues, say them. Tell them to your doctor. Have your children tell them to the doctor. If your child has thrown temper tantrums, tell it to the doctor. You might think the doctor doesn't want to know about it. Put it out there. Say it to the doctor and have the doctor, make sure the doctor writes it in the record. Get the record documented. Don't say everything's fine. Explain what the symptoms are over and over again, every visit, every time. IEPs, save them, because you're going to need them when your child applies for disability benefits. They document the problems that your child has had. And if you go to IEP meetings, be sure that you express at those meetings all the challenges that your son or daughter has experienced. Get it into the records. Okay.
By the way, we've had a number of situations where folks have applied for CDB years after 22. Those records, even though they're painful, I go along with Avi, keep them, right? These are incredibly
Absolutely.
valuable documents.
Don't throw out these records. Don't operate under an assumption that your medical providers are saving their records. And don't operate under an assumption that the schools are saving these records. You want to get all of them, and you want to keep them, particularly if you change doctors. You should be looking for these records. You should be keeping them, and you keep them forever. Don't ever throw them out. There's no 10-year or 7-year or 5-year rule. Keep them forever. Here are some examples of other types of records you can be gathering up and saving. I mentioned in this previous slide, teacher questionnaires. This is a questionnaire that, if you don't have IEPs, or even if you do, these are questionnaires you can send to a teacher to get the teacher to rate the students on a 1 to 5 scale among these 6 domains. And this can be used later on when you are applying for benefits. Okay. I want to now move on to post-award issues. The first one that I want to discuss, am I right here? Well, actually, I want to go back to this slide for a moment in terms of documenting disability. Make sure that your children's medical providers have documented any restrictions on the record. And eventually you may want to submit to your medical providers these forms to obtain from your child's physician or psychiatrist or psychologist a functional capacity assessment. A narrative is much better, but some providers don't like providing narratives. It takes too long. They think they don't write well. This is a checkoff that at the very least they can do. Now, in terms of post-award issues, the first one I want to bring up are PERC conferences. If you haven't heard of a PERC, it has not to do with an added benefit. Rather, these refer to pre-effectuation review contacts, and these occur with respect to SSI claims. If you are an advisor, you need to watch out for this because the agency, contrary to law, the agency routinely refuses to contact representatives for these PERC conference. They'll contact the beneficiary directly, and they'll set up a time to have the PERC conference. The purpose of these PERC conferences are to ensure that the claimant still meets the income and asset limitations of SSI. So a person might apply today for SSI and might not be awarded SSI until a year from now. At that time, the agency wants to make sure that the individual, the claimant, still qualifies and meets the income and asset limitations. So they'll contact the claimant to ascertain when the claimant will be ready for the PERC conference. They're not going to contact the claimant's representative. But I go to my clients' PERC conferences, and I urge you to go to them as well. Because at that PERC conference, the individual might be asked questions that they won't know how to answer, and that's going to delay an actual award. Or the person who's being asked the question might not necessarily be capable of handling their finances, even though, the very disability for which they were found disabled might also be a disability that would prevent the individual from handling their own finances. And that's why these PERC conferences are also used to determine if a representative payee is needed. And then finally, another reason to attend is they're going to ask the individual about what income they're getting. So if you've been giving the individual $100 allowance every month or every week, that's $400 a month. Then, and the person could dutifully respond, yeah, I'm getting $400 from mom, or I'm getting $100 a week from Uncle Bill. The agency is going to take the claimant at their word and write down $400 monthly income, and they'll automatically reduce the SSI benefit by $400 after the first $20. And it may be that the claimant is only dreaming that they're receiving it. It may be that they're not receiving anything at all. So you need to be there to ensure that the answers are correct and take care of it. And for those who are outside of California, anyone who is in the Second Circuit or the Seventh Circuit or in Texas, if in-kind maintenance and support is being provided in terms of room and board, that the agency will reduce an SSI benefit by 1/3 for room and board. Even if the room and board, the value of that room and board goes into the thousands of dollars, there's a presumed support amount of 1/3 the federal benefit rate. But for individuals in the Second and Seventh Circuits and in Texas who enter into a rental agreement to pay for room and board, and that agreement pays for at least 1/3 the federal benefit rate plus $20, can avoid a reduction for in-kind support and maintenance. And it's there in the regs and it's there in the POMs. So if you go to a PER conference, be prepared to show the rental agreement. And if the individual doesn't have any income, and you might say, well, when you apply for SSI, if you don't have a rental agreement, you should enter into one. And if the individual can't afford to pay anything because they haven't yet been awarded benefits, you should also enter into a loan agreement. And that loan agreement should not be dependent upon the SSI award. If it is, it'll be thrown out. But if it is dependent upon if it's you say in the loan agreement that the renter will pay back rent once they come into income, that you can put in there. What you cannot do is make it contingent on coming into income or contingent on receiving an SSI benefit. It's a fine distinction. The validity of the agreement can't be contingent on an SSI award, because if they're denied their award, then the loan is thrown out, and the agency will see that as a sham agreement. But if you say that the individual will pay back X dollars per month upon coming into income, that's valid, and you can keep that there. And while some agents, AAA reps may throw out the agreement saying that's not valid, it is valid, and that's an issue that can be appealed. And if you have a loan and rental agreement that calls for the payment of room and board that is at least 1/3 the federal benefit rate plus $20, then the agency can no longer reduce the SSI benefit on account of room and board, on account of in-kind support and maintenance. That's true in the Second Circuit, in the Seventh Circuit, and in Texas. And for non-attorneys who are listening, when I say to the Second and Seventh Circuits, I'm referring to the federal appellate circuit courts of appeal and the states that are within their jurisdiction. Okay. The second issue I want to address is return to work. If a beneficiary does return to work, there are different programs and considerations. In all cases, you must notify the SSA if you return to work, even if it's only for $10 or $20 a week. That will keep you out of trouble. It will avoid having income, benefits reduced when the agency later finds out about it, because in the middle of the night, Social Security computers and IRS computers whisper sweet nothings to each other. And you want to avoid having the SSA learn about what the IRS knows. Better to tell them first. So, therefore, if your child is returning to work, maintain careful records of what they earn each month and what they are paid each month. So if they are receiving a weekly check or a biweekly check, then if it's direct deposited, keep track of it, and keep track of it forever. Keep it on a spreadsheet So you don't have to go back 5 years later and start figuring out, now, what did junior receive and when did they receive it? You also want to avoid your child going over the substantial gainful activity amount. And if the payment is going over that amount, you want to either find IRWEs that can reduce it, those are income-related work expenses, or subsidies. And if there's no subsidy and there's no IRWE, then you should know that if their child goes over the substantial gainful activity limit, it is going to reduce their children's disability benefit in the event they go over that limit for more than 9 months. That gets into the issue of trial work periods. That in and of itself could be a 2-hour seminar. I'm just going to briefly mention that trial work periods are available for Title II beneficiaries, not Title 16 beneficiaries. Title II beneficiaries who, well, actually, it is available for Title 16 beneficiaries as well. It's just that substantial gainful activity is not an issue that a Title 16 beneficiary has to be concerned about, because there are other rules that will allow the Title 16 beneficiary to continue to work even if their earnings are above the substantial gainful activity limit. But what a Title 16 beneficiary does have to be concerned about is a continuing disability review that might find that there's been medical improvement. And if the individual has earnings over the SGA level, the agency might conclude that there's been medical improvement, not directly because of working over the SGA level, but because if they're working over the SGA level, the agency will then send that individual for a consulting medical examination. And that consulting examination might find that the individual has medically improved. And then they will lose the CDR. So you still have to be careful about going over that SGA limit for that reason. The trial work period has a lower threshold than the SGA threshold. And if the lower threshold, which is, I believe, is around $900, $910, if the individual goes over the lower trial work period threshold for at least 9 months in a rolling 60-month period, that will mean then that the benefits, the Title II benefits, will stop after the 2nd month following the 9th month of trial work. However, that will only happen if the individual then goes over the higher SGA level. And if the individual goes over the higher SGA level 1 month and then is below it the next month, for a 36-month period following the conclusion of the trial work period, the individual is in what is called the extended period of eligibility. And during any one of those 36 months, if they fall below SGA levels, they can receive their benefits automatically. They have to let Social Security know, but they would be, because you're automatically reporting your earnings on a monthly basis anyway, or you should be. However, there can also be expedited statement within a 5-year period from the month that benefits terminated due to SGA. So I've discussed the trial work period, which is a Title II issue only. The lower threshold goes up to $940 for a trial work period starting in 2021. Okay. I'm going to briefly mention overpayments here. If you do get into a situation where a client has an overpayment, then you want to appeal that. If you appeal the overpayment, it is going to be on the merits only. So if in fact you are overpaid, you will have to pay it back. However, if you are overpaid and you can't afford to pay it back, you may be able to get waiver of the overpayment. What's critical is there has to be an absence of fault, and recovery would either have to be against equity and good conscience or defeat the purposes of the act. Defeat the purposes of the act means basically you can't afford to pay it back. Against equity and good conscience means you change your position, like you decided to go to a community college, and you never would have chosen to do that if you knew that your benefits were going to be reduced because of the overpayment. If, in fact, you get into an overpayment situation, it's really good to find an attorney that can help you with this rather than trying to do it on your own. And if your child is qualified for SSI, you should be able to go to legal aid to get help with this. So these are the two pathways that one can challenge an overpayment. You can always file for waiver if you can show absence of fault and that it would meet one of these two tests. But an appeal has to be filed within 65 days, that's 60 days plus 5 days mail rule of the notice of that first notice of overpayment. So don't ignore it. Deal with it right away. And if you are filing within 10 days of the notice, you can avoid stoppage of benefits because of the overpayment. But it has to be filed within 10 days. And if you ultimately lose on the overpayment, you might ultimately owe a very large overpayment that's even larger than what was originally determined if you've been receiving benefits during the pendency of the claim. If you ultimately lose the overpayment and you're receiving SSI and therefore you're receiving Medicaid, or even if you're only receiving Medicaid, you can argue for a payback plan that has no more than a $10 reduction of the benefit that is being received, and that's in the PALMs. So that's important to be aware of, even if you lose the overpayment appeal. We've already talked about age 18 redetermination, so I'm not going to revisit it here. And we've already talked about CDRs. I'll just mention briefly that if a benefit claim is won, you're not out of the woods forever. Rather, the agency is charged with conducting continuing disability reviews. And these reviews happen every 3 years where medical improvement is expected, or every 5 to 7 years where medical improvement is not expected. These medical improvement not expected cases are MINE cases, M-I-N-E for short. And there are special rules regarding MINE cases, which again, getting down into the weeds, not enough time to discuss it here, just be aware they exist. Finally, with respect to all of these work issues, you should be aware of the Social Security Red Book. The Social Security Red Book provides detailed information on employment supports for people with disabilities, and it's written in a way for the layperson to easily understand, and they specify which rules and supports apply to Title II beneficiaries, which apply to Title 16 beneficiaries, and which apply to both. Okay. It's important to know that there's a different distinction between representatives and representative payees. They are not the same. Representatives represent and advocate for claimants before the Social Security Administration, whereas representative payees receive benefit payments on behalf of beneficiaries who are unable to manage their financial affairs. Rep payees must use the benefits to provide for the beneficiaries and their needs. If you are going to be a representative of someone, an authorized representative, not a rep payee, you must file Form 1696. Only a claimant or a claimant's guardian or parent, if the claimant is a minor, can appoint or revoke an authorization of representation. If you have a disabled child who is not a minor and there's no guardianship, only your child can appoint an authorized representative. Your power of attorney is worthless when it comes to the Social Security Administration. Absolutely worthless. Doesn't matter at all. Only if you have guardianship can you then hire someone to represent your child on your child's behalf. Or you could appoint yourself to be the authorized rep if you don't want to hire an attorney and you feel that you can handle it yourself. Not that I would recommend you doing so in a difficult case. In certain limited circumstances, a minor might appoint a representative. The appointment is effective the date that the client signs the notice of appointment. Anyone can be a representative, don't have to be an attorney. Non-attorneys, however, non-attorneys who want to get paid for their services have to complete an exam and be registered with the Social Security Administration. And there can be more than one representative on a claim. Legal guardians are not automatically representatives. Neither are executors or representative payees or interpreters. None of these are automatically authorized reps. In order to be an authorized rep, you have to be appointed through Form 1696. Be aware that if you are an attorney or you're a non-attorney rep who is registered with the agency, you cannot charge a fee for work before the administration without agency approval. There are certain circumstances where a court can approve the fee in lieu of the Social Security Administration. And if you do not obtain approval, you can go to jail and you can pay a fine. There is a process for obtaining a fee, and there are certain individuals who can appoint someone to be an authorized representative without, and in those circumstances, not seeking a fee approval before the agency. That is, if you have a third-party entity paying the fee, and a third-party entity is a business or a firm, not an individual. And a third-party entity cannot pass liability to for the fee to the claimant or the auxiliary beneficiary. I would argue that you cannot have your trust, which is for the benefit of the individual, being the third-party entity. It really needs to be a government agency, a business, or a firm, but not an individual or a trust that is for the benefit of the beneficiary.
And I mean, I think I know the answer to this, but does a conservator or a guardian automatically qualify, or do they still need to apply as a representative?
They still need to apply as a representative. A conservative or executor does not automatically qualify as authorized representative. And that is why their numerous phone calls to Social Security will go unanswered and unreturned if they attempt to call the agency and ask questions. Now, what I often do with potential clients is I will put the potential client on the line with me when I call the agency. I'm not yet an authorized representative, but I have the potential client there to authorize the agency to speak with me while I ask the questions that I want to ask to find out about the claim or prior claims or so forth. In one case, I had the agency say, we won't allow a friend, or we won't allow an attorney to be on the line. We will only allow a friend. That gets back to the agency culture. A claimant can have anyone on the line they want with them. Can be an attorney, could be the president, anyone they want. It's not for a clerk to decide who gets to be listening in on the line. But clerks like to play the role of God, and they like to exercise their power. And if they feel intimidated by an attorney, they will say, no attorneys. And if you can't live with that, I'm not talking to you. Okay, so you can hang up, call back, and try and get a different clerk. Or you can push the agency on it if push comes to shove, but it's really easier just to call back at another time and get a different claims rep. Let's move on here. We've talked about authorized representatives, but representative payees are a totally different animal. Rep payees are not authorized representatives. These are people who are selected by the agency to receive benefits on behalf of a beneficiary. They are selected if the agency has determined that the beneficiary is not able to manage or direct the management of benefits payments in his or her interest. Sometimes you can get a doctor's signature to that effect, and that's good enough. If you want to be a rep payee, you have to file an application, and that is listed here. It's form SSA-11. Rep payees have to provide an annual accounting. However, spouses and parents are exempt. That was recently changed, and I've cited to the provision in the agency rules regarding that. That doesn't mean that if you are a parent or a spouse, you should not be keeping track of what's being paid out, because the agency can still ask you to provide an accounting if they want to. Secondly, if you have a rep payee account, only Social Security benefits should be going into that account, nothing else. That account should not have, not even the earnings that an individual receives from the job they might have. The rep payee account should be dedicated for the benefits only, nothing else. And there are reasons for that. First of all, it will help you keep track of how those benefits are being paid for. And you might say, well, it's all the beneficiary's money. Why can't his earnings go into that account as well? If for any reason there is a need to claw back benefits, agency can claw back benefits from that account. So if you put your beneficiary's earnings in that account, they can claw back that as well, and because it's in the account. You don't want the agency to be able to touch anything that is not a benefit to the beneficiary. So have separate accounts. Only Social Security benefits should go into the rep payee account, nothing else. And by the way, beneficiaries may not have access to the payee account. It's right there in the agency guidance, the POMS. Recently, the agency, and this is because of a change in the law, the agency has developed a form for providing advance designation of a rep payee. Only a claimant may exercise this option. If the claimant is incapacitated, the claimant may not exercise the option. If the claimant has guardian, then the guardian could, in theory, exercise the option, but it's not clear from what appears in the POMS, at least at this point in time. If the advanced designation is advisory only, it expresses the desire of the beneficiary, and the agency is charged with honoring it. But if they think it's not in the beneficiary's best interest, then they are not bound by the advanced designation. So if you have a son or daughter who does not require a guardian, they are an adult, only your son or daughter has the capacity to determine through an advanced designation who they want to be a rep payee. I think we've already shown this code, so I'm going to move on.
Right, is that number 3?
No, this was code number 2.
Oh, okay.
And we've already shown it.
Okay.
Did you want me to go on and show code number 3 at this point in time?
Well, we probably need to, because I think we're starting to lose some folks.
Okay, right. So here is code number 3, 7211.
And once again, for those of you that are watching, we will be adjusting the amount of time upward. We had no idea how long this was going to take, and
I might add, I didn't either, because although I have spoken on all these subjects previously, I've put together for this presentation the contents of about 3 or 4 different presentations. So as a result, we've gone much further in time than I had initially anticipated. I want to move on to the topic of the talk. Everything until now, in some ways, has been preliminary. We're talking about maximizing household benefits in CDB cases. So this is an hour and a half in and of itself, and we obviously don't have that amount of time. But you should be aware that if you're talking about parents applying for retirement benefits and they have children who are minors or disabled who might also qualify, you might think that maybe the parent should apply as early as possible in order to trigger these other available benefits. The problem with that is that if a parent applies at their earliest possible date, they could apply for a retirement benefit, which is at age 62, the parent will experience a reduction of benefits on account of earnings due to the earnings test. Individuals who receive Social Security benefits over and they are below their full retirement age will be subject to a reduction if they have earnings over an annual threshold. That annual threshold is relatively low. It's about $18,000. It's between $18,000 and $19,000. I think it's $18,240. So the reduction is $1 for every $2 over the annual threshold. So there's good reason for parents to not apply before full retirement age. Additionally, retirement benefits paid before full retirement age, as I stated early on, are reduced. And the reduction can be as much as 25% for individuals for whom age 66 is full retirement age, and as much as 30% for individuals for whom age 67 is full retirement age. Full retirement age used to be at age 65, but Congress increased it to age 67 back in 1983, and they instituted a 22-year plan for gradually increasing Social Security benefits. Individuals who were born on or before January 1st, 1954, have age 66, or I should say January 1st, 1955. They're born on or before January 1st, 1955. Age 66 is full retirement age for anyone who's listening to this program now. Individuals who are really old, for whom age 65 was full retirement age, should already be receiving their benefits, probably are not listening to this presentation. Individuals who are born after January 1st, 1955 will see an increase in full retirement age gradually at the rate of 2 months per year up until age 67. So an individual who applies early for their retirement benefit is going to see a reduction in their benefits. That's another reason why they should be waiting till they reach their full retirement age. But you're trying to coordinate the retirement benefit with a potential spousal benefit available to the spouse who has not filed a claim, as well as the disabled adult child. Now, if the spouse who is not the wage earner is not filing a claim, has in their care a disabled adult child, they will be eligible to receive what is called a spousal in care benefit. That's also 50% of the primary insurance amount of the wage earner on whose account benefits are being claimed. But the wage earner gets 100% of his benefit. The child that is supposed to get 50% as a children's disability benefit, and then the spouse who's not the wage earner is getting a spousal and care benefit that is 50% of the primary insurance amount of the wage earner. That's a full 200%. And that's more than the maximum family benefit that is allowed. And that maximum family benefit rule, which is a complex formula, which I explain in the slides, but I'm not going to explain it here, limits generally benefits payable into the household to no more than 175% to 180% of the primary insurance amount on the earnings record of the wage earner who's filed for retirement benefits. So that means then that the spousal and care benefit and the children's disability benefit are going to be proportionally reduced so that no more than 175% to 180% of the benefits are paid into the household. Now, I'm going to skip over a lot of material here because we just don't have time to go through it all. But the point to keep in mind is that there are, actually, I want to go back to, not there. Okay. I wanted to go back to the case study. as well as some cautionary notes. If you're trying to juggle the retirement benefit and the children's disability benefit, as well as the benefits payable to the spouse, it is impossible to determine in your head, or even with a spreadsheet, what strategy is going to maximize benefits. There are thousands, tens of thousands of claiming strategies when you take into account all these benefits. The only way you can know for sure is by running the data through a software program that will account for all of these options. There's only one program on the market that I am aware of that is able to do that, and that's called Maximize My Social Security. I use it in my practice, and I pay for it like everybody else, so you shouldn't think that by my mentioning it, I'm getting some sort of kickback. I pay for it like everybody else, but it's the only program on the market that I'm aware of that is able to handle children's disability benefits. And if anyone listening to this is aware of any other program that can handle it, please let me know. I've looked at about 30 of them, and I have not seen any program other than Maximize My Social Security that can handle children's disability benefits. And it requires an individual to enter their earnings into the record for the software program. Both spouses need to enter their information into the program, and then you can run different scenarios. I use it in my own practice in order to assess what is the most optimal claiming strategy. I have tried to guess. Sometimes I guess well, and sometimes I don't guess well, even after doing this for many years. You really need to use the software program in order to determine what strategy will maximize benefits. I would like to go back to the case study that I mentioned at the beginning of the talk. Steve, if there are any, because I give the answers to the case study in the materials, maybe if there are other questions that you would like me to answer, we should do that now before I get to the case study.
We have quite a few pictures, quite a few questions here. So I'm kind of wondering if maybe we should plow through this and then do the questions, but I'm more than happy to do it in reverse.
Okay, so we'll plow through it now. And if you want to interrupt and ask some really good questions, you're more than welcome to do so. Remember, this is the couple, David and Lisa, who were in their 60s. They've come for advice. They have a son who's on the spectrum at age 23. He's very bright. He tried college, didn't work out for him. And he has tried a number of jobs, but it didn't work out, except that he got a really good job at this brokerage firm. But he took twice as long to perform the work, and after 14 months, he was let go. And he spends his day reading, playing video games, and he needs frequent reminders by his parents to take his meds and change his clothes, take showers, and so forth. And there's also this looming inheritance from grandma, who has this $300,000 estate. So David, who is now at age 65, wants to know if he should apply for retirement right now. He's only asked about the rib, and he's never even considered that his child might qualify for any disability benefit. So the answer is, what do you say to David? And there are all these questions. So we're going to go through them one at a time. First of all, should Arthur apply for SSI, CDB, or both? And does it matter for which he applies first? So if possible, he should apply for SSI first in order to get Medicaid. As I explained earlier, if he applies for both CDB and SSI first, by rule, the agency is going to consider the SSI claim first. So you don't need to be concerned if they're submitted simultaneously. They can be submitted simultaneously. However, you do not want to submit the CDB claim first and then later apply for SSI, particularly if the CDB claim is one which will pay benefits well in excess of the federal benefit rate. Even if the SSI is lost due to later eligibility for CDB, Medicaid is going to continue, as we explained earlier. However, what about DIB? The child might also apply for DIB. He worked, remember we said, for 14 months. That means he's going to have 6 quarters of coverage. You don't need to actually work the quarter. You can earn 4 quarters of coverage in one day. You can earn it on January 2nd. Now, they won't be applied until the end of the second quarter. If you earn 2 quarters of coverage on January 2nd, that second quarter will not be applied until June 30th. But this son at age 23 will have 4 quarters of coverage, 6 quarters of coverage, and could apply for DIB. But be careful. If the DIB is large enough, it could torpedo Medicaid eligibility. And you might say, well, he only worked for 1 year, 1.5 years. How could it be so large? Well, remember, I said that we haven't talked about the benefit formula. I did say, or I do have in the slides, that benefits are based on the highest 35 years of one's earnings record. But for really young beneficiaries, all those 35 years are not counted. In this case, only 2 years would be counted. And 2 years with an average of, say, $14,000-$15,000 a year, 24,000, so it's 12,000. That's still going to be a relatively high benefit, and in some states might disqualify for Medicaid. So you need to be careful about applying for DIB before you apply for SSI. What problems will Arthur encounter if he applies for CDB? So Arthur has to apply for disability prior to age 22. At age 23, that might not be too difficult. Age 30, it could be more difficult. And you might think, well, Arthur has a congenital condition. We don't have to worry about it. You should know that exactly 2 years ago, almost to the day, I was at a hearing where a psychologist who claimed to work for the Mayo Clinic, he was an independent contractor and he handled determinations independently. He was not an employee. He claimed at a hearing, my client, who was on the autism spectrum, had no disability prior to age 22, and claimed that there was no evidence in the record of a disability prior to age 22, even though my client had a congenital condition. Now, it is true, there was no medical evidence in the record from before age 22. There were reasons for that. But the fact that he had a diagnosis from a renowned medical center of his condition, even though that diagnosis was at age 30, that's conclusive proof that he had this condition prior to age 22, because there's no medical evidence to the contrary. I mean, it's known that the condition is congenital. So this psychologist was willing to lie on the stand because, again, he was an agency hack who was interested in getting paid by the agency. So a person who is beyond age 22 could have a problem proving that the disability was continuous. And then we've talked about that before. It could be that the work that the claimant had was a subsidy, and it certainly was in this hypothetical. Pay was above the market rate for the work that was actually performed. And so this can be documented and provided. So on what basis would Arthur qualify for a disability benefit under Titles 2 or 16? So there's listing 1210, autism spectrum disorder, and the A and B criteria, which we've discussed previously, are listed here. And we know that Arthur would qualify. Arthur gets into arguments easily. He cannot interact well with others. He has difficulty in remembering instructions. He can't perform more than 1 or 2 step instructions. So he is markedly limited in that capacity. And he can't stay very long on a task. He goes from task to task. He can't concentrate well. And he has trouble getting himself to and from work. So he can't manage himself. Arthur would qualify in this case. we can provide this evidence for the fact that he has a disability, the diagnostic tests, the IEPs, medications, narratives from relatives, and keep a diary. That's very important. If you have not started a diary, you should start one today. Keep a diary of incidents that take place. Write about them. A contemporaneous diary is worth its weight in gold. Is Arthur insured for disability insurance benefits? And if so, will disability insurance benefit award torpedo SSI eligibility? So we already said that Arthur had six quarters of coverage. And the benefit that he will receive is his primary insurance amount. And I've calculated it out here. I give you instructions in the slides how to calculate a primary insurance amount. And it will be 1166. So 1166 will torpedo the SSI claim. That is the fact that because it is higher than the SSI benefit. So actually, I said average index monthly earnings were 1160. Average monthly earnings are 1166. The primary insurance amount is actually 930, not 1166. And at first glance, this DIB is going to totally offset the SSI. However, the SSI is going to be established first, and thus at least until the DIB starts, after the 5-month waiting period, Arthur will qualify for SSI and then Medicaid. And if he then loses SSI, he may still qualify for Medicaid, notwithstanding his higher disability insurance benefit. Based on special rules, there's a special rule for individuals who are working, as well as for individuals who lose SSI on the basis of a CDB claim. When should David apply for benefits for himself? David should not apply for retirement insurance benefits until the claim for SSI is established. And then when David applies for retirement insurance benefits, Arthur can apply for CDB. The ALJ will not likely consider the period prior to the date of the claim for any CDB, for any DIB award. So if Arthur applies, we say in this scenario, age 23, if he applies for DIB and CDB and he's awarded benefits, he will still have to undergo a determination as to whether or not he was disabled prior to age 22. So in this case, Arthur did not begin working until age 22. Thus, while his SSI claim may trigger a DIB claim, it will not establish a period of disability prior to age 22. Note that an ALJ's determination on an SSI claim only after age 22 establishes disability as of the date of the SSI claim, but it's not administrative res judicata with respect to establishing a period of disability prior to age 22, since ALJ did not consider disability prior to the date of the SSI claim. Res judicata, for the non-attorneys on this call, on this webinar, is a legal doctrine that basically states that if a matter was previously determined, then it is binding precedent for any future determinations involving the same individual, the same issues, the same facts. One should also consider if Lisa, that is the mom, should file first by running her data through software in order to determine the best maximization strategy. Are there any concerns with respect to grandma's desire to leave a portion of her estate to Arthur? Oh, you betcha. Grandma should not leave her estate to Arthur because that's going to cause him to have an excess resource. Subsequent transfer to a trust would result in a need to establish a first-party trust. That is, if she leaves everything to Arthur, Arthur would then have to transfer it to a first-party trust. So grandma should write a check to a third-party special needs trust and not to her grandson in order to avoid Arthur receiving any income. And her will should be changed if it doesn't take this into account, instructing that any devise or legacy goes to the trust and not to Arthur. And the same goes for any other relatives who might be thinking of leaving anything to Arthur. And I'm sure your special needs trust advisor, Steve, can help you further along those lines. Can you give advice without petitioning the SSA for fee approval? Yes, you can. There's an opinion letter sent to NOSCR, which is the National Organization of Social Security Claimants Reps, in 1982, where the agency approved the practice of charging a fee to evaluate a case, not to represent someone before the agency, but for a one-time evaluation. The agency says this is not services. There is no representation here before the agency. But if you file a claim, you cannot charge for representation without SSA approval. And that's in the statute as well as in the agency guidance. And as I said, I think I said on that last slide that I had in the slides a copy of the letter. I don't, but I can send it to Steve, and they can send it to you. If
we'll put it in the Dropbox.
You must use benefit claiming software in order to determine the maximization strategy. There's only one software program, and I mentioned it here and the website here. And again, I don't get anything for this. It's just they're the only program that does this that I'm aware of. And if anyone listening to this knows of any other, please let me know. And with that, I have a few tips. You should contact a local office with questions regarding a case. It used to be difficult to find the local office's phone number, but you can now go to the Social Security office locator and they put the number right there. Avoid the 800 number at all costs. The people who answer the phone there know very little. They're not going to be able to help you. Many know less than nothing. Remember, regarding fees, you need 1696 to become an authorized rep and to submit, and you have to get fee approval. Ignore what I wrote here about Form 1695. It no longer exists. It's now been added into Form 1696. Be sure and you use the Form 1696 that was revised in 2020. Do not use earlier forms. If you have a non-contingency case, you can represent someone. Just be sure to get a retainer up front and put it in your own client trust account. You will have to submit a fee petition to the agency to get approval for any fee. With that, I think we are done, unless you have, well, I've listed additional resources here, and there's a glossary in the back of this slide deck that defines many of the terms we have used. So if you have additional questions that you want to ask, I can stay for a short while and answer some of those questions. That's
okay. And for those of you that are doing this for credit, we are going to adjust the credit up. Evrim, did I mention that my observation is that disability and simplicity are two words that don't go together? Here and once again, I will tell you, for those of you that are not familiar with Avi here, Avi understands this better than anyone I know. He's been incredibly giving with his time here. Once again, for those of you that have been watching this for credit, at this point, we are going to adjust that upwards, but let's plow through the questions as best we can. Sure. And also, this will be up, I hope, by the end of the day. If not, it'll be done by tomorrow. If not, then I'll return every cent that we took from you, which is nothing. But there we go. Okay, let's go through this. My child with a disability receives a higher CDB because I claim SSA retirement benefits and now has $783 of Medicaid share of cost. She is still eligible for QL-1 benefits. I intend to get her Medicare supplement. What should I be concerned about?
Wow. Okay. So you have to, I apologize. You have to start over again. The child is already receiving CDB?
Yeah.
And the child is, and the CDB is in excess of how much did it say?
We don't have a dollar amount, but but now getting a $783 Medicaid share of cost. Oh, we're getting a share of cost. By the way, Avi, I did post the palms having to do with pickle and other related. This is not a pickle issue, I understand, but
Right.
I always find it just under the pickle
Yes.
portion. So I did post that. I would wonder, why do you have a share of cost? Or there must be some other income out there.
I don't know. I don't know the lingo share of cost. I may know a lot. I don't know what that lingo share of cost is referring to. And I don't know what QL-1 refers to either. If this individual is receiving a children's disability benefit that is over $803, then there is not anything you can apply for. You can't apply for SSI. If the children's disability benefit is under $803, the child may be eligible for SSI. However, if the child is working, those earnings, even if low, could reduce the SSI to zero. For example, if the children's disability benefit, let's say, is $750, and then the child is earning $200 a month, it's not very much. But after the first 65, you're left with only 135, and that's divided by 2. And so that gets you to, $78, $77.50, or $67.50. 67 added to the $750 children's disability benefit is going to be over $783. So they're not going to qualify for SSI. If the child has a work record, you might want to inquire if the child is eligible for a disability insurance benefit on their own earnings record. However, there's a set-off. You can't get both CDB and DIB, additively. Rather, you get your disability insurance benefit first, and if the CDB is above that, then you get the excess, the difference between the CDB and the DIB. So I hope that has answered the question. I'm not sure what else. I mean, you should be always paying attention to earnings that your child is making because of these issues, which I've talked about previously.
And I'm about 2 clicks away from saving the palms on this here in the Dropbox about the Medicaid part. That actually kind of goes beyond this. Another source, though, to look, and I will make sure, I'll also copy Avi's links towards the end with a few links that I have of my own. And one of them will be a program called Disability Benefits 101.org, which actually has calculators that can help this person try to figure out why they have such a high share of cost. I think there's some information we're missing, and probably more than we can handle today. Let's see if we can knock off another one. By the way, QI is qualified individual. Thank you, whoever helped that. For CDB intake, if a person became eligible for SSI at 18 and is now 20, and it's now 20 years later and applying for additional CDB, how far back does supportive medical disability documentation need to go? Prior to 18, from 18 to present?
Okay, so you certainly need to go back before age 22. They qualified for SSI at 18. But if you're now 20 years later, Social Security is not going to have any of those records. So they're not going to have the medical records. So the fact that they were awarded benefits, 20 years ago, means that they were also awarded before 2017. So the prior determination is not going to be conclusive to a current CDB claim. And in fact, the current CDB claim will likely be denied if you have no medical records that date from prior to age 22. So you need to find those medical records as best as you can. You need to find school records, contemporaneous diaries, anything that, and if you have nothing else, then you need to get statements sworn statements from relatives and friends who might have known this child before age 22. However, absent medical records, if all you have is the SSI award and the sworn statements, it's a very tenuous claim. It can be done depending upon the type of disability. But for example, if the individual is on the spectrum, the agency, and even if you have, statements from friends and relatives, unless those friends and relatives can really go back and discuss in detail what happened when this client was at age 17, 18, 19, 20, it's going to be very difficult. They can't just say, well, Johnny was always a problem in school. That's not descriptive. That doesn't explain how Johnny was a problem. So you need to be very descriptive, and you need to go back and find those old records. That's the best, that I can say. How far back? Well, if you've got records from age 1 through age 22, you don't need the records from age 1 to age 16. But, the more recent the record, pre-age 82, the more helpful it will be. So records for the year in which the beneficiary was age 21 are the best, right? Because it demonstrates disability before age 22, right before that threshold was crossed.
I mean, I know and I know this isn't a slam dunk for anybody, but, for folks with behavioral health, mental health diagnoses, this can be particularly difficult because it's not unusual that they were definitely disabled before the age of 22, but it's not uncommon that they don't get their SSI or other benefits until years later. We had a case where it looked, I think we applied when the person was 40 here, and this is a very desirable program. And what saved us was in the bottom of a box here, we found all the school records, and that's what sealed the deal. And as the parents said, oh, I was hoping never to look at these again. I understand. Do not throw those away. Okay, that meant a lot. And one of the benefits of all of this is, once again, there's not an income or resource limitation on this, that sort of thing. It just has to do with, are you disabled and did you need it? I mean, if you can qualify for this, this is a very desirable program.
Right. Absolutely.
Okay, let's see. 31-year-old. Oh, by the way, for those of you that are watching and have been doing this for credit, the credit portion is over. We're just going into questions and answers again. Here we have something from Meredith. She says, my 31-year-old has been disabled continuously since 18. At age 18, was dependent on his dad, but now is not. The dad just became eligible for retirement at 65. Not yet FRA. Can 31-year-old disabled independent son get increased cash benefits on Medicare rather than Medicaid? If so, must application be submitted by 31-year-old son or representative or by 65-year-old dad? Well, there's a couple of questions in there.
Right.
Who applies?
Who applies for what? So first of all, when you say dad retired, it's not clear if dad retired from his job, or if you mean that he's actually applied for and is receiving retirement insurance benefits under the Social Security Act. Retirement from work in and of itself does not trigger any benefit payment. One has to apply for the benefit in order to receive the benefit. So if someone retires at age 60 from working, they can't even apply for a benefit on their own earnings record at that point. They have to wait at least till age 62. And at age 62, the agency does not automatically pay a benefit. They don't automatically pay a benefit ever. You have to apply for the benefit. So dad has to apply for a retirement benefit in order to even trigger the possibility of the son becoming eligible for a children's disability benefit.
And then the son or the son's representative would need to apply.
Right. Then that's right. At that point, once dad applies, dad should indicate on his application that he has a disabled adult child. That's number one. Number two, the disabled adult child ought to be applying for a benefit at the same time that dad is applying for the retirement insurance benefit. Doesn't have to. You can get up to 6 months retroactive payment, but it would be ideal to get them both going at the same time if you can. And then thirdly, it was not clear if the son is receiving any other kind of benefit. If whether the son is or is not, the son will still have to prove that they are entitled to a children's disability benefit on the basis of being disabled before age 22. By the way, it could happen that if a parent has a very low earnings record, that the children's disability benefit is less than the SSI benefit. The SSI benefit 783. The children's disability benefit might only be 500, or maybe it's 700. And you might think, well, why bother applying for the children's disability benefit when I can't get anything higher on a monthly basis? Because after all, what will actually happen is that the child will get 500 for the children's disability benefit and then 283 for SSI.
A whole $20 a head.
Right, and there'll be $20 a head because of the $20 disregard for unearned income. But other than $20, it's essentially the same. Yeah, so they get $20 more. So you may think, why bother? Bother because after 24 months, the child will qualify for Medicare. That's the holy grail, if you remember. It's the ability to get the Medicare. That's why you want to get the children's disability benefit. And you might think that your son is already getting, or your daughter's already receiving good medical care. Great. But with Medicare, options for care open up because not everybody accepts Medicaid.
More providers and all that. No, there definitely is a pony in the whole thing. Here's one that I know half the answer. Maybe you know the other half, and I think I just lost. Oh, here we go. Can a child who receives SSI receive CDB living outside of the U.S.?
Yes.
Well, for SSI, as I understand it, the rule is you can't be out of the country more than 30 days.
Right.
How about CDB?
CDB, there is no requirement that you have to live in the United States. You can be anywhere in the world. And I have clients in Israel receiving CDB benefits, or former clients, rather.
For those of us heading to Canada, we might want to keep that in mind. I'm sorry about that. But anyway. Here's an interesting one. What happens if a child receives CDB and an annuity, a pension, because the parent was a federal employee? Might this disqualify them from Medi-Cal? Well, that's a Medi-Cal question. If the monthly amount is more than the eligible earnings for Medi-Cal, the child's been on SSI for many years. I should have read that first. That's really.
It sounds like it's a Medi-Cal question, and
it's a Medi-Cal question, and it's an income question.
Right. I will say this: the CDB will not be reduced $1 by any annuity payment that is received. On the other hand, if the child is eligible to receive an annuity payment and is also receiving CDB, I don't know what impact, if any, the CDB might have on the annuity payment. That's
that's something I probably could answer if you wanted to email me, but those are that's not a simple equation. Well, this may be more like how many angels on the head of a pin. If a parent, although there's a good point here, if a parent applies for SSI on behalf of an adult disabled child, let's say they just apply for anything, and they are turned down, should they appeal on their own or engage an attorney such as yourself? And I'll kind of add to that, Avi, there's certain things where I don't think it's incredibly difficult to find a Social Security disability attorney, and there are some areas where It's really tough. And I'll give you a clue. That's rarely going to be your special needs trust attorney. I mean, I know some that do, most don't.
Now, there are a lot of attorneys that, I mean, on a straightforward disability claim, there are a lot of attorneys who practice Social Security disability law. And it's always best to have an attorney in your local area to handle a disability claim, because they will know if this is a case that's going to go to a hearing, they're going to know the ALJs in that area. And even if they don't, their colleagues will know them and they can ask questions about them. And it happens among I practice Social Security disability law as well. It's just that I happen to know these other areas. And if I don't know an ALJ, I can ask a colleague about an ALJ, locally. Very easy to do. But I don't know the judges in Seattle or in Miami or Houston or California, for that matter. So it's always best to have a local Social Security practitioner if possible, and they are well suited to handle, one who's experienced is well suited to handle disability claims. So if you've been, to answer your question directly, if you've been denied on an initial claim, there is a reason you were denied. It may be because you don't know the type of evidence that you need to present. So you might try to, you go to the clerk's going to say, sure, you can appeal. You want to appeal? And you say, yeah. So now you appeal and you're denied on your own and you're denied again. Now you're at the hearing stage. Now you're thinking, oh, a hearing. I need to go find an attorney. In the meantime, the attorney is coming into the case with 2 strikes against you already. They've not had the opportunity to get a first bite at the apple with an initial claim or a second bite on reconsideration. Had the attorney known before you filed for reconsideration that the only reason that claim was denied is because you didn't submit any medical evidence, because you thought all you had to submit was documentation that the client was previously awarded SSI, and you don't know about legal doctrines of collateral estoppel and res judicata. So the attorney does, and you might have a plethora of medical evidence. You just don't know that that's what you needed to supply because you thought the agency already had it. So the attorney on your request for reconsideration will submit all that medical evidence that's overwhelming, and the claim will be won on reconsideration. And the attorney has avoided the time and trouble of going to a hearing. Hearings take a lot of time. There's waiting. You could wait up to 2 years or longer to go to a hearing in some parts of the country. You don't want to do that. So the answer is an unequivocal yes. You should go find a competent attorney who is able and understands what kind of evidence needs to be presented in a case like this. If the agency doesn't if the attorney doesn't understand they need to have evidence of disability from before age 22, go find a different attorney.
And also, Avi, we probably have a lot of parent advocates that are incredibly proud of their children and love to show off all the wonderful things they can do. My understanding is when you're applying for Social Security, this is not the time to be bragging on all the wonderful things your child can do. I mean, sadly, SGA is kind of based on something else. So
right. That is really an important point, Steve, and I'm glad you mentioned that. It is not the time, and it goes back to something I said earlier about when you go to a doctor's appointment, be sure to share all the problems and make sure that the doctor gets that into the record.
Yeah, and I know for many this kind of goes against the grain, but I mean, this is what we have to do. By the way, maybe with some advocacy someday and change in leadership and all that, maybe it'll change, but I don't see anything changing in the near future.
I agree.
Even with the change of administrations, nothing's going to happen immediately.
I agree.
Yeah. We'll take a couple more, and then
Sure.
Mrs. Dale says it's lunchtime. So Mrs. Dale says it's long past lunchtime. Okay. Let's see. Here's one. If we submit a neuropsych to prove disability, how old can the report be? Is an annual physical visit summary enough to prove disability? Or is there some kind of form letter or that sort of thing? I think I know what the answer is, but.
Okay, this is a really good question. And unfortunately, we didn't have time to elaborate on this during the talk, but I'll do so now. First of all, an annual physical, it really depends on the disability. If the annual physical is going to check on how the patient is doing, are they maintaining, are they stable? If they're stable, the medical record might say no problems, patient doing fine. And that doesn't discuss at all the fact of that the patient is a paraplegic, maybe has cystic fibrosis, but has been maintained well, on their meds, et cetera, et cetera. So you don't want to rely on the annual physical, and particularly in mental impairment cases. So you do want to have you want to have a current neuropsych evaluation. Current means within the past 12 months, maybe the past 18 months. But if that neuropsych eval is, 6 years old, I would, particularly for younger applicants. I mean, if you're talking about someone at age 23 and the last neuropsych was, at age 13, yeah, you do want to get a new neuropsych evaluation. And you also want to get a neuropsych evaluation from someone who genuinely understands not only the condition that your child has, but is ready, willing, and able to write the evaluation in such a way that it addresses the 4 domains of functionality. And if they're not ready, willing, and able to do that, you should have a conversation with them in advance. And maybe your attorney should have a conversation with them. If they're not ready, willing, and able to do that, go find a psychologist who is able to do that. And it tends to be the older psychologists, not someone who's in graduate school working on their PsyD and has been assigned the task of administering all the tests for a practice. They might be a very good test administrator, but they're too young and not willing to go outside of the box. And they don't learn about the domains of functionality in grad school. So you should be careful who you use to provide that neuropsych evaluation. You want to make sure that they have some familiarity and understanding of those domains of functionality. And if not, educate them so that they can they can connect the results of the neuropsych evaluation to the degree of non-functionality in each of those 4 domains.
Okay, and this is going to be the last one because I got to go to lunch. You need to go to dinner. And by the way, for some of us, we've been sitting here for 3.5 hours. You need to get up and move around here, get that blood flowing, guys. Okay, but I mean, I learned a lot from this. This is going to be the last one today, and then we'll do our closing. Can a 30-year-old adult who received a mental illness diagnosis at 21 and who has worked off and on and never collected benefits apply in the future for CDB under the parent's record because they are higher than the individual record? I think getting back to the core of this, we got a 32-year-old here got their diagnosis, which doesn't mean that the disability didn't begin before 21. It just means that's when they got the diagnosis. Mm-hmm. But if they got the diagnosis at 21, but they worked on and off, but never collected benefits.
Right. So first of all, it depends. The real answer is it depends. You need to find out, first of all, how much they worked on and off. Where did they have a string of employment that was more than 3 months at a time? Because anything 3 months or less is considered an unsuccessful work attempt. And if it was more than 3 months, For how long was it? Was it for 5 or was it for 25? And were they getting a subsidy? Were they getting, were there income-related work expenses? If there was no official subsidy, go back to the employer. Find out how the employer, how your child handled the position. If you have substantial gainful activity over the limit, if you have earnings over the limit for an extended period of time, unfortunately, unless you're willing to go to the mat, which means going to federal court, you're not going to be able to challenge the continuous disability requirement. You have to be able to show a subsidy in order to overcome earnings in excess of the substantial gainful activity level. But if you don't have earnings over the SGA levels and you just have a string of failed work attempts, even if there were more than 3 months, if they're all under SGA levels and the last neuropsych eval was, say, at age 21, get a current eval and then use the old one plus the new one to show that he's been, and the failed work attempts all provide evidence that this individual has been continuously disabled from before age 22.
Okay. Boy, Avi, I have a bunch of letters after my name because I was a professional student. I know you do. This stuff confuses the hell out of me. Imagine somebody with a severe disability trying to wade through this morass. So it goes back to my initial observation. Even though the concept of childhood disability benefits is incredibly simple, the application is not. And we go back to the word simple and disability just seem to be two words that don't work together. I think a lot of this for you family members out there to appreciate this, not only, is this a challenge for you, obviously trying to do the best for your child that you can, but just imagine here the advocacy that's required to do this sort of thing when you're not around, and the importance of having good fiduciaries and attorneys who can at least identify the issues here. Avi, I learned a ton today, and maybe after my third time of reviewing this video, I'll learn even more. But I want to thank you so much here. Last words for you, and then, man, it's dinner time.
I agree. I think I've said all that I have said. I do have contact information on the front slide, and if you have difficult issues, you know how to reach me. I can't promise that I will be able to respond to every question that is submitted, but we'll do our best.
And for you advocates out there, there's got to be really, I think there's some work to be done. Anyway, with that, I want to thank you for attending here, and especially for the 61 folks who stuck it all the way to the end. Here, we broke records this time with this presentation here. I will do my best to have this up on the YouTube channel here, if not today, by tomorrow. And once again, I want to thank you so much, Avi, and for our audience out there, have a good day and happy advocating.
Thank you.
If I can hit the end button. Oh.